Supplementary list fresh admission item number 1.
No instructions.
Supplementary list item number 2.
Item number 2, Millers. This matter is covered by Keshav Automobiles, Millers. But I have just formulated my additional questions, Millers. I have given one memo to your Lordship, Millers. Your Lordship, I will turn to page 27, Millers. Page 30, findings of the tribunal. Starts from page 27, how it has dealt in. Page 27, second paragraph, Millers. The dealer challenges the order of the Law and Assessing Authority for the first time of the following ground, that the Assessing Authority has directly resorted to assess property under Section 43 of the OVA Act without assessing the appellant under Section 39 of the OVA Act, which is mandatory. Then your Lordship, kindly see page 30. Only he has referred to the findings of the authority below, saying that if your Lordship will turn to the second paragraph, subparagraph, paragraph 7, after 2 questions have been dealt with by the first authority in the appeal order, as per finding of the first authority, the dealer has already been duly confronted with all the points, allegations, sufficient opportunity. And this is and the contents law and advocate on behalf of dealer apparent that the instant dealer has not been assessed under 39 is not true. So nothing there is any communication, nothing. So it says that 39.
All right.
That's the only point.
Admit the following question is framed by consideration. Then reproduce the question. It is not in dispute that for the period in question, that is 1st April 2012 to 31st March 2013, the order of assessment, reassessment dated 25th November 2013 under Section 43 of the OVA Act was not preceded by a communication by the department of the acceptance of the self-assessment return filed by the petitioner dealer under Section 39 of the OVA Act. Full stop. Consequently, following the decision of this court in Keshav Automobiles, Manu OR 05802021, which has been affirmed in Plati Steels. And further, by the order of this court in the third one, the impugned reassessment order and the corresponding orders of the first appellate authority and tribunal are hereby set aside. The revision petition is disposed of.
Deeply obliged.
All right.
Supplementary list item number 3.
I have prepared a date chart, my lord, small date chart. In this case, my input test claim has been disallowed on the ground that the selling dealer has committed wrong and is having a fake registration certificate. My lord, I have on 27/9/2020, I purchased goods from a registered dealer at the value of rupees 3,14,116, and I paid the GST and SGST, and the valid invoice is with me. Secondly, then on 39/2/2020, another invoice was there.
Anyway, notice he accepts notice.
Your Lordship, this
and issue is already covered by various high courts has
Your Lordship, this is the 74 adjudication order, which is appealable, Your Lordship. And the petitioner has challenged this order by saying that there is no annexure to the order, there is no enclosure to the order, only format has been given. Your Lordship, the order sheet is here. Your Lordship, enter reason. A reason order has been passed by the assessing officer and which is appealable, Your Lordship.
Only issue is that
I have photocopied it from
they have disallowed my claim of ITC on the ground that the selling dealer is a defaulter.
Your
It's
Lordship,
an appealable order.
Your Lordship,
The issue has already been covered, my lord. My lord's judgment is there.
Yeah,
Supreme Court judgment is there.
You point that out in appeal.
Supreme Court judgment
this is the detailed orders. Detailed order has been passed by the assessing officer.
They issued me so cause notice. I find my reply without giving me any opportunity of hearing their past the order.
All that.
And this issue has already been covered, my lord. My lord's judgment, Supreme Court judgment is there.
All right.
I'm also having the compilation, my lord.
All right. So you point out all in the appeal.
My lord,
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to challenge the impugned order by way of an appeal as provided in the OVAT Act, is it?
Your Lordship, GST.
GST, OGST Act. Disposed of is withdrawn with liberty is prayed for. All right.
Item number 4.
Your Lordship, I am appearing for opposite party number
Yes,
1 GST Council, item number 3.
This is, my lord, the GST tribunal matter, my lords,
Mm-hmm.
where the entire tax has been paid at by virtue of the orders, which your lordship would get it at page 53, my lords.
Or in that IA, that notice, you say 8 weeks reply and all that. List on 18.
Lords, I have a very humble prayer, my lords.
Yes.
In your lordship may just say that no coercive action for the interest and penalty part, my lords.
All right. In that IA, you say counsel for the petitioner points out that the entire tax demanded has already been paid. Accordingly, it's directed that during the pendency of the present writ petition, no further coercive steps towards interest and penalty shall be taken against the petitioner.
Till
The IA is disposed of.
till disposal of the writ petition.
Writ petition?
No, till disposal of the writ petition.
That's right.
My lords. Greatly obliged, my lords.
Lordship, I am appearing for opposite party number 1 to 3.
All right.
Item number 5.
Your Lordship, item number 5 on behalf of Mr. Knight, the matter has been already in fructus. I may be permitted to withdraw.
All right. Disposed of is in. All right.
Item number 6.
No instruction in the matter and necessary order.
All right. No instructions necessary.
Item number 7.
My lord, one prayer after launch can we take accommodate?
All right.
My lord.
Item number 8.
Please, your lords. Chairman, Lord, the petitioner is an Anganwadi worker challenging the order under Annexure 3, which was passed by recalling my order, which was in my favor on the basis of which I was appointed. On the ground that I have played fraud and court. My lord, the subject matter of dispute in the appeal, which was the which I had challenged being agreed by that order, is available to your lordship at page 105. Your lordship kindly see. That order consists of 2 parts. One is for issuance of notification for filling of the post, and my prayer to accommodate me because I stood for second. And the consequence of the resignation of the first selected candidate, I was supposed to be appointed as per the Sukanti Jena's case, which is laid down by this honorable court. And on the basis of that judgment, I was given the relief. Subsequently, and when I approached my lords, the honorable single judge passed an order: any decision taken in this writ petition shall be subject to result of the writ petition. This fact was not taken note of by honorable single judge while recalling that order, saying that I've played fraud on court by not bringing to the notice of the court that notification has been issued in the meantime. During pendency of the case, notification was issued for appointment of the respondent. The respondent was appointed by virtue of the subsequent notification. I was appointed, and subsequently, since my prayer was refused, I approached the honorable single judge. Honorable single judge passed an order directing any decision shall be subject to result of the writ petition. But that fact was not taken note of. If that is accepted, then there is no fraud. State also didn't bring to the notice of the court. There is a 3 days notification. Within the order, impugned order, the notification was issued immediately 3 days after the impugned order, which is available to your lordship after 105, page 105. That notification itself is a subject matter of dispute in the writ.
No.
Fresh notification.
The basic point was you did not implead this
Because she was not appointed by then. By then she had not appointed, and order was passed. Any decision taken in the notification, fresh notice shall be subject to result of the writ petition. And thereafter, my lord, I also approached the contempt forum. My lord, thereafter I was appointed. Neither state nor the petitioner was able to brought to the notice of the court about this development. And a particular order was passed. Your lordship can see any decision shall be result as a subject to result. Your lordship can see page 46. Page 46 glance. Honorable single judge categorically stated that any decision taken in the writ petition shall be subject to result, which is the subject matter of issuance of fresh notification. Fresh notification is the subject matter of dispute and that writ. Your lordship can return to page 46. And the ratio decided in Sukajana case has been given a go by.
Absolutely no reason assigned, my lord. That is my responsibility. I am a poor Anganwadi worker working since last 2 years.
No, but by the time this court disposed of this 26347
Yes.
on 27 January,
Yes.
opposite party number 5 was very much respond number 5 was very much selected already.
By then, my lord, that was not brought to the notice of the court. I was also not aware
So
because
then
3
either
days.
way,
That was subject matter of dispute. My lord, your lordship kindly turn to page 46. Kindly have a glance. If it is not within my knowledge, your lordship kindly turn to page 46.
No.
It is absolutely not
Page
within my.
69 para 8. I think the entire facts are properly set out.
Yes, my lord, it is there, but it has not been taken out. That is my grievance, my lord. Page 46 has not been taken note of, though it is my trump card. Your lordship kindly before the honorable single judge, this was the trump card. If once there is an order and court took cognizance of the fact that any notification issued subsequent to the entertainment of this writ petition, that will be subject to result of the writ petition. By then, nobody was appointed. By then, page 46 can leave a
That was
glance.
2018.
Yes.
After that, you know who
it
got
was not
selected
within
was
my knowledge.
new advertisement.
With great respect, it was
You
not
did not
within my
challenge-
knowledge. I would say staying outside.
1 minute.
Because I lost there. I couldn't get the interim order. I stayed there outside. I was not there in the village.
No question. You did not
Milord, it
challenge.
is
You did not challenge the new
even
advertisement.
2 proceedings, Milord, state has not brought to the notice of the honorable court that this is the development taken place.
All right.
And your lordship kindly see that is also subject to result of the writ petition.
Yes.
And the ratio decided in Sukhanti's case, my lord, given a go by.
No,
And a right is accrued by virtue of an order that cannot be slightly. And the fraud is to be specifically pleaded saying that it was within my knowledge.
yes.
Within 3 days, there cannot be any appointment within 3 days, my lord.
Mhm.
In the behind my back, these appointments were made and which is subject matter of dispute in the earlier writ petition.
Mhm. All right. The challenge in the present writ petition.
Your lordship kindly consider, my lord, it is now seized overaged.
That's it. That's one more reason then.
My lord, you see, present petition is overrated and she is continuing there, my lord.
Yes.
There is no other source of income.
No question. The challenge in the present petition is to an order dated 6th February 2023, passed by the single judge, allowing writ petition civil 8716 of 2020, filed by respondent number 1, Anita Behra. Full stop. By the said impugned order. The learned single judge recalled the earlier order dated 27 January 2020, passed by the court in writ petition civil 26347 of 2017, and directed that respondent by shall be immediately reinstated in her post as Anganwadi worker bracket AWW of the Kielanda Anganwadi Center bracket AWC in question bracket under the CDPO Dalang, the district of Puri. Stop. The background facts are that an advertisement was issued in 2006 for appointment of an AWW at the aforementioned AWC. Full stop. One Mamtanjali Biswal was initially appointed as AWW on 20th December 2008. Full stop. She, however, resigned on 15 January 2009. Full stop. Meanwhile, the present appellant filed AWW Miss Appeal case number 23 of 2009 before the sub-collector Puri, stating that she should be engaged as AWW as she was second in the merit list.
Second, in view of the ratio decided in Sukhanti Jana, reported in
So
2013.
reliance was placed on the decision of this court in Sukanti Jaina v. State of Orissa 2013 1 OLR 391 in support of such prayer. However, the said appeal was rejected by the Sub-Collector Puri on 23rd November 2017. Paragraph. The said order of the Sub-Collector was not further challenged.
Yes, sub-collector order was subject matter of dispute in my writ petition.
No, subject matter of dispute is one thing.
Pardon, my lord?
You challenge that in the writ petition.
Yes, earlier writ petition.
Right. You say challenging the above order.
Including the observation for issuance of press notification. There was a direction that for
writ petition civil number 26347 of 2017 was filed by the present appellant in this court. Paragraph. Meanwhile, there was a fresh advertisement issued on 30th November 2017, which was neither questioned by the appellant, nor was there any stay of the said advertisement, nor was any stay of the process of selection pursuant to the said advertisement sought for or granted. Full stop. Pursuant to the fresh advertisement, respondent 5 figured in the first position in the merit list. It may be noted here that the present appellant did not participate in the selection process pursuant to the fresh advertisement. Paragraph. It appears that in writ petition civil 26347 of 2017, there was an interim order passed
on 5/1/18 at
1 minute, sir, 1 minute, please. On 5th January 2018 by the learned single judge, stating that any action pursuant to the fresh advertisement would be, open quotation, subject to the result of the writ petition, unquote. By this, it became clear that not only was the appellant aware of the fresh advertisement, but the above interim order itself made clear that the steps taken pursuant thereto would be subject to the result of the writ petition. Paragraph. The selection of respondent 5 as the successful candidate in the fresh selection was definitely known to the government, although the appellant claims that she was unaware of that development. Full stop. As a result, respondent 5 was not made a party to writ petition civil 26347 of 2017. Full stop. The said writ petition was then heard by the learned single judge, without the participation of respondent 5, and an order was passed disposing it on 27th January 2020. Quashing the order dated 23rd November 2017 passed by the Sub-Collector Puri in 8 WW Miss Appeal number 23 of 2009. Full stop. A direction was issued to consider the case of the present appellant in light of the judgment in Sukanti Jaina Supra. And engaged the appellant as AWW of the AWC in question. Paragraph. It is in the above circumstances that Respondent 5 filed writ petition civil 8716 of 2020, seeking recall of the above order dated 27 January 2020, which had been passed behind her back, depriving her of being engaged as AWW. Paragraph. The learned single judge has, in the impugned order dated 6th February 2023, noted the sequence of facts. Also, this clearly revealed that prior to the order dated 27 January 2020, the selection process pursuant to the fresh advertisement was already completed. And Respondent 5 stood selected for being engaged as AWW at the meeting of the selection committee held on 28th December 2017. Stop. She had joined as AWW on the following day, that is 29th December 2017. Full stop. Paragraph. Despite all these facts being known to the government, no effort was made to bring these developments to the notice of the learned single judge, who was hearing writ petition civil 26347 of 2017. Full stop. It was obvious that Respondent 5 had to be made a party to that writ petition, as any decision in favor of the present appellant, who was a writ petitioner, would have a direct adverse impact on Respondent 5. Stop. It is in this context that it was pleaded by Respondent 5 in her writ petition that a fraud had been played on the court by suppressing the subsequent developments, that is, the events taking place after the filing of the writ petition. Full stop. Counsel for the appellant repeatedly urged that the appellant was not aware of the fact that Respondent 5 had been selected pursuant to the fresh advertisement. And even the government did not bring this fact to the notice of the single judge when the order dated 27 January 2020 was passed. Full stop. It must be remembered that when the order dated 27 January 2020 was not complied with by the state, the present appellant filed contempt case number 1635/2020, in which an order was passed on 10th June 2020, directing the appellant to be immediately reinstated as AWW and be allowed to continue in service. What was the order? Do you have a copy of that order in contempt?
Well, that order is available to your lordship. No, contempt order I have not given. Contempt order.
Clearly, even in the contempt case, when the order dated 10 June 2020 was passed, the court's attention was not drawn to the fact that Respondent 5 had in the meanwhile been selected and engaged as AWW pursuant to the fresh advertisement. Full stop. with the appellant certainly being aware that her writ petition, that in the course of the pendency of her, that during the pendency of her writ petition, the selection pursuant to the fresh advertisement was already taking place. The appellant could not plead innocence about not finding out who was selected pursuant to that fresh advertisement. Full stop. The interim order itself made it imperative for the appellant to ascertain the result of the selection process pursuant to the fresh advertisement. Full stop. In other words, the appellant cannot possibly plead ignorance of that development. Full stop. Therefore, notwithstanding that it was inexcusable for the state not to have brought to the notice of the learned single judge the fact that respondent had in fact been selected as AWW pursuant to the fresh advertisement, an equal responsibility lay on the appellant as well, since the appellant was certainly aware that the process of selection pursuant to the fresh advertisement had not been stayed, and all that had been done by the interim order was to clarify that that process would be subject to the result of the writ petition civil 26347 of 2017 filed by the appellant. Paragraph. No order in the appellant's writ petition could have been passed without impleading respondent 5's party. Full stop. The learned single judge has rightly, therefore, recalled the order dated 27 January 2020 in the said writ petition in favor of the present appellant and directed that respondent 5 should immediately be put back as AWW of the AWC in question. Having carefully considered the above submissions of learned counsel for the appellant, the court is not persuaded that any error has been committed by the learned single judge, which calls for interference. But stop, the writ appeal is dismissed.
May I say one thing? Because it is also responsible of the state. State has not dealt. And I'm not arguing. My request only, my lord, your lordship may ask the state government to consider my case because I was there for the last 2 years. And since 2006, I have been running for this post.
Item 9.
The lordship, she can't approach bullet.
9 is that staff of court, if my lord would see the order number 47 dated 21/9/2022. So that was in September 2022. Thereafter, in January, they wanted time.
228 posts are created. Rest of the post, I have taken instruction. It will take some time. I will also fix it to March.
Take some time in what?
March.
All right. Counsel for the learned AGA, Mr. Kuntia learned AGA states that the process of creating the remaining posts is underway, and it should be, and as per his instruction, should be completed by March 2023.
The 31st March, after the election, may fix it after 31st March.
Okay, by the end of March 2023. Stop. List on. April 11th.
Item number 10.
Item 10, my lord. Private opposite parties number 4 to 7, they are creating the disturbances for the easement right. I have filed the suit and suit has been declared under annexure 3, my lord, at page 17, operative person. The learned trial court has granted the injunction restraining the private opposite. Still, I have brought the notice to the collector and the Tahsildar regarding that demolition because they have constructed a building over a road. That is a government road. And it is a annexure 1, my lord, at page 9. ROR has been enclosed. Where so this they have constructed a road over the government passage, which create the disturbances for the easement right of the petitioners, so also the other publics at large. And my grievance is also pending for the learned collector under annexure 3.
All right, sorry, 4. At page 2.
Copy has not been served. So
Copy has been served.
no, we haven't received it.
All right.
My lords,
Where's the proof of that? Proof of delivery of the order representation, sir.
Annexure 4, my lord.
All right. The petitioner's representation, bracket annexure 4 series, shall be considered by the collector,
Collector Puri.
and after notice to the petitioner, as well as opposite parties, 4 to 7, and after giving them a hearing, the reasoned order shall be passed not later than 2nd May 2023, and be communicated with the parties within a week thereafter. The court clarifies it is not expressed in the matter.
Okay.
Item number 11.
Your by the annex number 1, a notice to leak out a sent sorat was made, my lord. And thereafter it was opposed by the villagers, and accordingly police by the annex number 2 was organized, my lord. Wherein also resolution was made that to oppose the same as because the particular process, my lord,
Same thing, sir. Acknowledgement. Where is the acknowledgement of the receipt of
annex number 3? Annex number 3.
acknowledge.
That I have filed, I have not filed, madam, sorry.
Counsel petitioner seeks to withdraw the present petition with liberty to file a fresh representation to the authorities, and after following up on such representation to seek appropriate remedies.
Item number 12.
Well, my lord, the petitioner's grievance is that, my lord, the illegal mining of the snail and the small creatures from the sea belt of the villagers within the parameter of the 20 kilometers, my lord. They are illegally mining the snails and the other creatures.
Mining? So we are sitting here.
My lord.
What is mining? You're mining snails. I don't understand.
My lord, the small snails, Samuka, they are collecting and mining to the West Bengal, my lord.
Mining? What is mining?
Or they're collecting and they're selling. They're transporting from the coastal belt of the Odisha and mining to the state of the West Bengal, my lord.
Sir, don't use the word mining. My English is very weak. Don't make it weaker.
Sorry.
When you extract mineral, it is mining.
Yes, my lord.
When you pick up snails from the beach, that's not called mining.
Yes, my lord. I'm sorry, man.
No. Don't have to be sorry. It's just the expression using.
My lord.
Can you go to the NGT, sir? Do you have a remedy in the NGT?
Yes, my lord.
You do. All right. So please go there.
Representation is on our annexure 3 that is pending before the collector, my lord. Also, my director to consider, otherwise
not necessarily
agreed to approach the NGT, my lord.
No. You can go now only, sir. Counsel for the petitioner seeks leave to withdraw the present petition with liberty to approach the National Green Tribunal in accordance with law. Disposed of his withdrawal with liberty is paid for. All right.
Item number 13.
Item 13 and 14. Mr. Harichandan is not well, my lord, sir.
I see. Counsel for the petitioner is stated to be unwell. List on 31st August.
Item 15.
Item 15. I pray for next week, my lords. My brief is misplaced somewhere. I'll get a copy.
At the request of counsel for the petitioner, list on 30th August.
Item number 16.
Lordship, matter can be taken up next week. My senior counsel is
counsel for the petitioner is stated to be
obliged
in some difficulty. List on 12th September.
Item number 17.
Your Lordship, may I please, Your Lordship? Your Lordship, may kindly turn to the question of law at page 20. It is also covered that SDP, oven sacks, SDP fabrics, Your Lordship, whether plastic goods or not, Your Lordship, the tribunal has held that it is not plastic goods. Your Lordship, it has already been covered by Your Lordship judgment. Two judgments, Your Lordship, Paratarani robber and also Chilika fishing in both the cases.
So let me issue notice. Just give it back. So notice returnable 12 September. All right.
One, but I lost. That authority, I lost.
Your Lordship, my Lord Chini was there in that case.
All right.
I tried to persuade, but I failed.
All right.
Item number 18.
You have made a far better lawyer out of Mr. Mishra. He will himself acknowledge. Every time he has to meet you, he has to raise the level of his performance. All right.
Item number 18.
None appears dismissed.
Item number 19.
Item number 19, 20, 21. The defects at the original impugned order has not been filed. I have already collected. 2 days may be granted. That's what it is.
All right. List on. All right. List on 6th March, defects be cured in the meanwhile.
Much obliged.
Your Lordship, for item number 20, we are instructed to appear for Nalco.
I'll give them a
20. Okay.
Lordship.
I'll give them a
Copy may be served.
I'll solve it.
Obliged, Lordship.
Item 19, 20, and 21. Item number 22.
May I please be noted? Lordship may kindly turn to page 16, my lord, annexure 1, my lords. Lordship got me?
Yes.
Here, my lords, an action by the enforcement unit Sambalpur was started, my lord, initiated on 16/10/2019.
Yes.
For the period, if Lordship would see, 1/7/2017 to 31st of March 2019. My lord. Your Lordship would get it at unnumbered paragraph 2.
Yes.
And I was called upon, my lord, to produce my entire books of accounts. My lords. Thereafter, my lord, while this was pending and I've already submitted my books of accounts, basing on some information from the enforcement unit Raulkela, my lord, by annexure 2 at page 17, I get a notice, my lord, on 23rd of October 2019, my lord, when this proceeding before the enforcement unit Sambalpur is on, my lord. If your Lordship would kindly turn to page 17, my lords.
Yes.
There your Lordship would see there's the information is from DCCT GST enforcement unit Raulkela, my lords. And annexure 1, it was Sambalpur, now it is Raulkela. So I appear before the authority, my lords. I tell them that the enforcement unit Sambalpur, my lord, has taken up this assessment for a larger period, which includes June 2018, for the month which you are now initiating, my lords. Then nothing happens for some time, my lords. Then all of a sudden, my lord, another officer joins, my lord. Now this particular officer, my lord, your Lordship would get his name, my lord, at page 19. He's Mr. Karan Soren, my lords. Then another officer joins, my lord, without any notice, my lord. He passes an order in annexure 3, my lords. So, for the same period of June 2018.
Appealable.
Sorry, my lords?
Appealable.
No, your Lordship would appreciate all my books of accounts are still, my lord, that enforcement action is still pending. It is for the period 1/7/2017 to 31st of March 2019. He picks up 1 month, that is June, my lords, 2018.
You can point it out.
No, I was only praying, my lords, I was not given an opportunity neither to file a show cause, nor, my lord, to appear before the assessing authority, my lord. All that I pray, my lord, is your Lordship may permit me to collect my or get extracts of my books of accounts from Sambalpur, my lord, appear before him, my lords, let him decide, my lords. Because now your Lordship would see, my lord, for the entire period from 17 to 19.
No, see, the point is you came in 2020. This writ petition was not even listed.
That was the difficulty.
Sir. Nothing's been happening. They're not also not raising any demand.
No, because I'm not, now, my lord, your Lordship would appreciate, my lord. I am now fastened with a demand, my lord. Now this enforcement action is pending. Now, my lord, your Lordship would appreciate that I am now fastened with a demand of 29 lakhs.
That's
and my lord, if I
deposit that 10%.
Lord, your Lordship, just one chance, my lord, one chance. Well, I'll appear, my lord. Your Lordship may say that within 15 days, let him complete the proceeding. But your Lordship may kindly consider this, my lord, because the enforcement action is still on. My books of account, even if, my lord, I file an appeal, my lord.
Clearly not. There are no coercive steps have been taken. Otherwise, you would not keep quiet.
No, my lord,
2 years, 3 years like this.
No, your Lordship may see my difficulty, my lords. All my books of accounts are still with the enforcement Sambalpur, my lords. So even if your lordship would relegate me to the appeal, my lords,
with your having enjoyed 3 years of peace, now you can at least pay 10%.
it's now. But ultimately, my lord, this particular alternate forum, my lord, has to be efficacious, my lords.
That's true.
And unfortunately, I am handicapped.
No,
because
fortunately, you have now some hundreds of orders saying if you pay 20%, you are rescued. God knows still when the actual tribunal will be constituted.
But that was, my lord, we are fortunate the union government has still not taken a decision. Your lordship would appreciate, my lord, one chance, my lord. No, your lordship see the entire extended period, my lord. Your lordship see the justice, my lord. I am, my lord, now faced, my lord, with 2 proceedings, one before the enforcement wing, one before the assessing of the office.
Clearly, they've gone to sleep. We've woken you up by listing it. Otherwise, you would have also gone to sleep.
No, one chance, my lord. I beseech your lordship, my lord, this. Beseech your lordship, my lord, to give me one chance, my lord. Let me get my books of accounts, my lord. Get the extract.
All that the appellate authority can.
Lord, March, my lord, I'll appear before them, my lord. I'll file a show cause.
The counsel of the petitioner seeks leave to withdraw the present petition with liberty to file an appeal as provided in accordance with law. If such appeal is filed not later than 10th April, along with an application for condition of delay, explaining the pendency of the present petition as the reason for the delay, it will be considered in accordance with law by the appellate authority. The court clarifies it has not expressed any view in the matter. There's no originals to be returned?
Originals, no, because we get downloaded. One small prayer, Lord.
Yes.
Lord, dear Lordship, may direct me, Lord, if I need my books of accounts to file an appeal, Lord, I'll approach the enforcement wing, Lords, because they are very sticky about, Lord, returning books of accounts.
No, always there. Photocopy, they can return the photocopy. No problem. These are 2 different.
I wish and hope, Lord, they're fair enough, like my learned friend, Lord.
You know, your Lordship authorities' anxiety to call the enforcement seized records. You have the vast experience. And you are doing that.
We get, my lord, stuck up in this scheme of alternative remedies. Somewhere, my lord, we get stuck up. Either with the enforcement or with the vigilance or with the...
No, now there's multiplicity of agencies. Actually, that is a big problem. Yeah.
Each wing, they try to outdo the other, my lord.
That's right.
And in this particular matter, my lord, they were conscious of the fact that from 17 to 19, my lords, the entire proceeding was pending before the enforcement wing. Still, they pick up 1 month.
I think basically, since there are no time limits for anything, people just, go off.
And most of these demands, my lord, are statistical, my lord.
Correct.
Ultimately, we do not have the wherewithals, my lord, and most of them. Now the difficulty, my lord, everything is sent by email. And in most of these people, my lord, especially these contractors, my lord, I'll just take 5 minutes of your lordship's time. They are, my lord, their passwords are there either with a chartered accountant, if they can afford a chartered accountant. And the chartered accountant, my lord, he maintains 1 for 100.
Everybody.
So he doesn't see it, my lord. So by the time the action is taken like a bank attachment, he wakes up and sees that the appeal period is gone.
But in Delhi, whenever they called me for all these lectures, I used to tell even the chartered accountants and tax practitioners that, how to be professional in the way you reorganize.
Correct, sir.
The businessman is simply not used to this kind of discipline. It requires a discipline of a very high order.
And overnight, my lord, we can't
change
transform.
Habits. Old habits die hard.
My lords. And we can't transform ourselves, my lord. None, my lord, check the email every day, my lord.
Same is going to be happening to lawyers, which is why I introduced the e-filing because you can't run away from it. Ultimately, all of you will be doing only e-filing. No. Checking will be done online. It is a matter of time now. So even as professionals,
but we are grateful
to reorganize ourselves.
But we are grateful to your lordship. At least an alert comes in a message. And an SMS alert comes.
No, and we're not making it compulsory yet.
My lord.
See, the problem with GST that overnight it all became the only way of transacting. So that's why people didn't get time.
Now,
In fact, they advanced the launch. If I remember very well, it was supposed to be much later. It got advanced to 1st July. So that created a huge chaos.
Actually, the service part actually is a lacuna. Actually, this order does not go to the assesses because through mail and through portal, because the dealers...
how many petitions not able to get onto the portal, not able to upload?
Your Lordship, that is...
Now, we have a constraint regarding filing of appeals. There's no limitation, my lords, for powers to condone.
Right.
We are handicapped that way, my lords. Ultimately, most of them go without a remedy. They go remediless.
And then Kar Vivad.
Your Lordship, we know everything, but still we are arguing that the court has no power, the appellate authority has no power to condemn the decision.
All right.
Greatly obliged. And Lord, regarding the books of account, Lord,
Add saying if the petitioner, it will be open to the petitioner to request the appellate authority for directions regarding the release of documents by the enforcement directorate.
And
for the purposes of pursuing the appeal.
Right. And to enable me to file an appeal, Lord, I'll approach them. Lord, I'll approach the enforcement wing, Lord, unless they give the books of accounts.
No, the appellate authority here will issue directions. That's what I've said. All right.
Petition also, you have the scope to file petition also, directing the enforcement to produce the books of accounts.
True, my lords. But before that, my lord, to prepare my grounds of appeal, my lord, I need my books of accounts. That is the whole problem, my lord. Some observation regarding that, my lord, sir.
Your Lordship, this is a differential. Fake ITC, Your Lordship. Nothing
fake ITC, everything is fake.
Your Lordship, that is there. And
for my learned friend,
the seller, here, Your Lordship, in their books of accounts, it is nothing, not related, Your Lordship. Why, Your Lordship? The sellers have not disclosed in their return. So this is the differential ITC, Your Lordship. That is, for that reason, this sort of
will cover. So the case has no merit.
And to prepare with the proof.
All right.
Item number 23.
Your Lordship, condone the delay.
Yeah, that is all.
Greatly obliged.
Right.
Item number 23.
May I please, Your Lordship?
Yeah, that's all.
This is regarding levy of interest on the CGST Act before amendment. This is Your Lordship's order. Another order is passed by my Lord Justice Raman.
Copy. Chapter opposite party we have copy them. I'm a chapter opposite party. I'm order.
All right, same order. That notice, date of the notice has to change, no sir? This dated 24th February will change.
Yes, my Lord. Date of notice will be changed, my Lord.
You have to change that. All right, we'll do it.
Same is, my Lord. 25.
All right.
27.
Okay.
28 and 29, my lord.
Your Lordship, I am appearing on behalf of the aggrieved party order. Let me go
Yes,
to
yes.
the order.
One
My
copy-
order, Your Lordship, Annexure 3 is my order and it's unfortunate.
Right. 26, what happens?
My lord, 24 and 26, against the appeal order, writ petition has been filed. I may be allowed to file second appeal before the tribunal. 24 and 26, appellate order has been challenged before your lordship. I may be allowed to file second appeal before the tribunal.
Here, Your Lordship, here the levy of interest has been challenged.
And levy of interest and penalty under section 10.
Lordship, may kindly
10.3. 10.3, my lord.
It is item 23, annexure 3, page 35.
Okay.
23. You are arguing 23.
No. 23 is only interest. 24 and 26 is the appellate order has been challenged. 24. The 23 is not yours. 23 belongs to union.
23 annexure 23 annexure 23 is the number 9413/2020. I am appearing on behalf of the opposite party number 4 and 5. My order is at annexure 3, page 35. That is the interest levied by the state tax officer, Bhubaneswar 1 Circle, Bhubaneswar. 23 9413/2020 Bharat Motors.
It is interest on the credit ledger. Interest on credit ledger only.
I am arguing the same thing.
So it's covered by that circular.
Covered by the order. Covered by this order.
This
23 is 9413 of 2020.
So this amendment already Finance Act 2021, the amendment has been declared as retrospective. So this part of paragraph 2 may not be required, Your Lordship, because it isn't admitted.
But that's why it's still there, alive as far as he's
Your
concerned.
Lordship, Your Lordship,
So it's actually a formality. Since these are pending writ petitions, this clarification has come.
Your Lordship.
Your Lordship, all these 5 items, I am appearing for opposite party number 3.
All right. Now come to 24. He just wants to withdraw to file a second appeal.
A second appeal before the tribunal.
24 and 26.
The petitioner seeks leave to withdraw these writ petitions with liberty to file an appeal before the tribunal in accordance with law. If such appeal is filed not later than 10th April, along with an application for condition of delay, it will be considered by the tribunal.
Your Lordship, in part that 23, at paragraph 3, Your Lordship may change the designation.
Date is being changed. Right. The originals will be returned subject to being substituted. Attested protocol.
Obligement.
All right.
Item number 29.
29. Same order.
29. So,
right.
I put 23, my lord.
Right.
Obliged.
Item number 30.
Memo taken on record. Dismisses in charges.
Item 31.
None appears dismissed.
Item number 32.
My lord, 32 is question of law at question of law, my lord, is at page 7, my lord. At paragraph G, whether the reassessment is liable to be annulled when the assessment under section 9 of the OAT Act has not been made. Covered by Xmas, my lord.
Admit the following question is framed. G, in view of the decision of this court in ECMAS, the above question is answered in the affirmative in favor of the petition SSC against the department. Full stop. The impugned reassessment order, the corresponding order of the first appellate authority and the tribunal are hereby set aside. The petition is disposed of.
I'm sorry, my lord. I was appearing in seal number 31, my lord.
Yes.
My lord, the issue pertains to challenge to proviso to section 2J, my lord. And the similar matters are pending before my lords on 22nd August, my lord.
All right.
Bill number 31, my lord.
Okay. List of 22nd August.
Indeed, my lord. The connected lead matter is my lord.
Maybe.
All right. List on 22nd August. All right.
Connected read number is 21892 of
Along with-
2012.
Along with 1892. All right.
Oblige. Item
Let's
note
see,
30.
copy may be directed to survey copy. Let's see.
All right.
Item note 33.
33, my lord, same, my lord, section 2J.
Same here.
And
Same
already 22nd
August.
Item 34.
May I please, Your Lord? My lord, I am in BC.
Yes.
I am having a sore throat. I couldn't attend physically. I may be excused.
All right.
My lord, this is, I have the annexure 3 and 4 may be dispensed with because it's a.
All right. Dispense with us all along. All right.
Yes. And my question of law at page 10, the question number 2, whether the petitioner's claim of ITC available during the end of relevant period having not utilized in the subsequent has been rightly disallowed by the Honorable Tribunal, opposite party number 3, in accordance to the principle of statute provided under that. If I take your honor to the page 15 of my STRB petitions, my excess ITC to be carried forward was 2,01,675. When I filed the subsequent period, I disclosed it is no carried forward. So I have utilized that ITC during the period, which should have been taken by the authority below while computing my demand of tax. If I take your honor to the Honorable Sales Tax Tribunal order at page. At page 47, Your Lordship got it?
Yes.
Para 6, after 7 to 8 line, as a matter of fact, the appellant has carried forward the ITC amounting to rupees 2,01,607 in this return filed in quarter ending 2013. Thus, the dealer appellant is entitled to utilize the carried forward of ITC for the year 13-14 onwards, which is beyond the period of audit assessment. During the course of audit assessment, I brought it to my knowledge of the audit. There was a provision because my audit was immediately after the end of the financial year. My audit was initiated.
All right. We'll just notice returnable. September. Copy the petition be served on. All right.
Obligement.
Item 35.
My lord, 35. Out of a common judgment, my lord, state has filed 2 revisions and assessee has filed 4 revisions.
When are they coming up?
And your lordship has fixed to 10th April, my lords.
All right. List on 10th.
Let's see, these 2 matters are covered also. Same, that SDP, Open Sachs and the plastic.
No, other reason.
10th April. All right.
36.
Same, my lords.
37.
The substantial question of law at page 21, my lord. Only Roman 2 I am placing. After amendment of the Act on 2015, the penalty twice reduced to equal to the tax payable, my lord. And the additional ground raised before the tribunal did not take it, not decided, my lord.
But this is against you, sir. This 9C5 is decided against you.
9C, my lord, only the. I am not challenging the.
That is.
I think there are other petitions.
Your Lordship,
State has come up.
if my learned friend will not.
State has come up.
9C
cases.
9C.
Where the tribunal has accepted the plea that it should be.
Your Lordship, many cases were here, and Your Lordship has issued notice of 9.5, Your Lordship.
Correct.
And also Your Lordship has already confirmed this 9C5 penalty. Your Lordship has confirmed by cognizing that.
The question he is raising, he is saying that it has
prospective effect.
Amendment has come in 2015, making it once
Your Lordship,
equal to.
Your Lordship,
that affects retrospectively. That is what.
My Lord, my assessment completed on 2018, my Lord. And the period is 14-15.
Your Lordship, this is the one time, one time is not related.
State
here.
has come up. State has lost.
Your Lordship, that is in where tribunal has allowed.
Yes.
Here, Your Lordship, tribunal has confirmed.
Not taken into consideration, additional ground.
The additional ground, the tribunal has not taken.
That is
That
not
is what you are facing.
That is my point.
Your Lordship, may issue notice.
Notice reservability. Well acceptable.
Obligement.
Item 38.
Winding up, no? Birla Tyres is winding up.
Yes, Lordship.
NCLT.
No, Lordship. Already it is covered by your Lordship's judgment in WPC number
No,
1.
I think this Birla Tyres is before the NCLT.
No,
Yes, recently.
39. I'm sorry.
It is 38.
30 copy has not been.
No, but it's before the NCLT.
My Lords.
The petitioner is before the NCLT. Consequently, leaving the petitioner to work out its remedies in those proceedings, the petition is disposed of. Right.
Item 39.
39, your Lordship, is already covered by your Lordship's order in WPC number 18216 of 2017. Pursuant to, but by mistake, I have supplied first page. I am supplying other 2 pages. I have missed it. Rectification of GSTR 1, your Lordship.
But all these dates have to change.
Yes, Lordship. I'm giving the correct.
I think give it same order with the correction.
Okay.
Well, I'm appearing on this. Yes.
Mr. Chimankar. All right.
Item number 40.
40, 41 permitted to withdraw with liberty to file fresh application if cause of action survives.
All right. Counsel, petitioner seeks leave to withdraw these petitions with liberty to file fresh petition per cause of action survives.
41.
Disposed of is withdrawn with liberty spirit.
Item number 42.
42, my Lordship. I just seek 1 week time, my Lordship, to remove the defects.
Listed on 2nd May, defects we removed in the member.
Item number 43.
My Lords, 43, I'm challenging the first appellate authority's order, my Lords. Kindly turn to page 14, my Lords. The pre-deposit was made by electronic transfer, my Lords. They have rejected that it has not reflected in cash ledger, my Lords. Your Lordship yesterday disposed of one matter. This circular has come. And your Lordship yesterday disposed of WPC number 28990 of 2020.
Harishchandra Maji.
No.
My Lords, yesterday your Lordship disposed of WPC number 28990 of
Credit list. Okay, same order. All right.
Item 7 yesterday's list.
Electronic credit ledger. Right.
Yes. Item number 44.
Your Lordship will remove the defect. Your Lordship will allow me to 1 week. This is a matter, Your Lordship, in the moratorium period. During the moratorium period, the assessment order has been passed.
Must be appealable, sir.
Now the company is under liquidation, Your Lordship.
Then that's all over then. NCLT.
My Lord.
The petitioner is stated to be before the NCLT, leaving the petitioner to work out the remedies in those proceedings. The petition is disposed of. So 44, 45, both.
Yes, Your Lordship.
Item number 46.
May it please your lordship? Your lordship, in absence of the GST tribunal, the
10%.
No, your lordship, the petitioner has paid the entire demand tax.
Counsel petitioner state the petitioner already paid the entire demand.
Lordship, similar orders for.
This has been rejected due to delay. First appeal.
13th September. 13th September.
Item number 47.
Memo taken on record. Dismissed is withdrawn.
Item number 48.
48 may not be broadly the issue will be covered by your lordship's order.
This one. This one.
This one.
Yes.
The date will be
same order. Third April.
Because pardon your lordship, in the 45 my delay, if your lordship is allowing me to go and appeal, there delay.
Not appeal. You just have to file an application there, sir. There's procedure there is different. IBC procedure is yes.
Item number 49.
In 49, I'm filing limitation in course of the day. Your lordship may call this matter next week.
Must be similar to some other matters, sir.
No, this is somehow different because in a similar case, Honorable Supreme Court has directed that similar benefit cannot be granted. The content cannot be granted. Your lordship may call this matter next week.
April. Defects be cured and made.
Item number 50.
50 melod prefer 2 weeks melod for emerald defect melod.
Same 11th April, defects be cured.
Item number 51.
May I please have lordship, my requisite filed on 20 July 2021, my candle accepted.
What?
20 July 2021, my lord.
21, sir, you file a fresh notice, returnable.
Both the cases.
13th September. That's it. All right.
Oh, please.
Item number 52.
Lordship, in item number 52, I am for the appellant. As per the office note, 14 out of the 61 respondents have passed away in the meantime. I'll file substitution petitions within a week.
All right. 4th September, say. 6th April.
Obliged, Lordship.
No, this is after notice, right? This is item 52.
52. Right.
This is after notice. There are so many. One is addressee deceased. Have you seen the remarks?
Yes, your lordship. The office note is there in front.
How much is the delay?
The necessary parties, lordship. Give me a week's time. I'll file all the.
Let's see how much delay. 89. Many respondents have yet to be served. Some are stated to have expired. List on 13th September. Notice is issued afresh to the unserved respondents, returnable on that date. The tracking report will be placed on record. Paragraph. In the meanwhile, wherever an addressee has died, the petitioner, the appellant will take steps to appropriate steps regarding substitution.
Supplementary list item 53.
Obliged, Lordship.
My lord, in 53 and 54, I have already complied. So we remove the defects since long. We have served on the government, also the required rupees are already paid.
No, nothing. Fresh matter. For it list on 53. 10th April, defects be cured in the meanwhile.
Here in both the cases, in fact.
Both the cases I have removed the case. In the both the cases, 53 and 54. Same matter.
You've removed already.
Already removed.
But it's not removed, it says. No, so many 5D, 5E, 9. What are the matters about? What is it about?
The matters I have challenged the remand order passed by the single judge on various grounds. And I pray it can be disposed of today. One ground is there that they have not fixed the time limit because I am fighting from 95. See, now I am helpless. I am a lady. The order was in my favor, but it was remanded because one interim order was not passed in the interim. There is a lot of grounds, whether it was maintainable or not, that writ petition, as virtue of that.
In fact, that petition was not entertained. But my learned friend is praying for your lordship can pass that order fixing a time limit. Though there is no time limit.
Time limit may be fixed so that it can be disposed of and will be.
So, but the maintainability writ petition was not entertained. The remand order was there. That was not adjudicated.
Yeah, there is a other grounds, but one ground I pray that direction may be given to dispose of that appeal.
All right.
By the opposite one.
The limited grievance made in the present writ appeal by the appellant. Bracket who was opposite party number?
Opposite number 2.
2 before the single judge. In writ petition numbers 19116 of 2018 and 18737 of 2018 is that no time limit has been fixed for the director to dispose of the it's all no time limit to dispose of the matter. Stop. The impugned orders are accordingly modified only with the addition that if the parties appear before the director through their authorized representatives on, now you never appeared now. So
we are appearing, but it could not be heard. That is the problem.
On 3rd April 2023, after hearing them, a reasoned order shall be passed within a period of 2 months thereafter. A copy of this order be sent to the director. Higher education, is it?
No.
Secondary education.
Secondary education. Forthwith.
In both the cases, same order.
Yeah.
Item number 55.
My impugned order is at phase 25, madam. This was disputed on the very first day. Earlier he has approached this honorable court and the honorable court had directed to consider his representation. That representation was rejected and that rejection order was under challenge. On the very same day that rejection order has been set aside, my lord, without giving the opportunity.
Nobody is there.
Notice.
First day.
Yes, ma'am. First day. And contempt petition is there.
All right. Notice stay of the impugned order. The meanwhile, list of 5th September. There shall be stay of the impugned order.
Item 56.
Item 56, similar matter is coming on 14th March, my lord.
31st March.
14th March.
14th.
14th.
1/4.
1/4.
14th March. All right.
Item number 57.
Submit, let's see.
I preferred an appeal challenging the order dated 23rd December 2022 passed by
single bench in the WPC number 36852 of 2021, challenging the rejection order dated 10th November 2021 passed by the Superintendent of Post Office, Mayurbhanj Division, that is opposite party number 2, wherein the prayer of the petitioner to allow the closure of 2 term deposit account and withdraw the amount deposited which has been rejected by the opposite party number 2. So that order is challenged, my lord, and a single judge rejected my petition and I am challenging that.
It is the case, sir. This fraud has been committed. The amount has been deposited with this joint account, and which was find out later on, for which this accounting fees equal because matter is investigated and found that he has committed fraud. This particular amount was committed fraud, and he deposited his own account by joint account officer. Now the related. This is the case, man. The Honorable Singhal has rightly passed order and observed the detailed order has been passed in this.
Your Lordship.
What is the amount in these two accounts?
Pardon, may I draw your attention to page 46 of the order, in which at page 47, it is mentioned that as per the provisions of Public Account and Deferred Act 1850, they have
No, my lord, I asking amount 5 lakhs and 2.5 lakhs like this. Different denomination account.
I don't disagree that
Sir, just listen to the question.
What is the amount standing on the credit of these two accounts?
2,50,000 each in 2 accounts. Term deposit for 5 years. After 3 years, I prefer to withdraw.
No. So what is the need for you to withdraw?
I faced gynecological problem to meet the treatment.
Where have you said this? Where have you produced the documents for?
No, I have not produced. I have given averment.
No, you produce documents, sir. You show us that what is your other finances. Make out a case. Make out a case. How does one know whether you have other accounts? What is the balance in other accounts?
I have no other account, my lord.
You should say that, sir. You should say, I have no other account. You should say, this is the expense I have to incur, since it is something to do with medical ailment, and how much expense you need for that. You have to make out a case. Don't take these things for granted.
My lord, the provision under which they have deprived me, that is Public Account Default Act 1850. I am the petitioner, is the wife of the accused person, and I will draw your attention to page number 49 and to section 3. For the purpose of section 1, 2, and 3 of this act, the expression public accountant means any person who, as official assignee or trustee, is entrusted with the receipt, custody, or control or any money or securities for money or the management of any land belonging to that. My lord, Section 4 of the page 50 specifies if at all accused is found guilty after departmental proceeding, avenues are there through his terminal benefits, service benefits, and also through a Public Account Default Act Section 4. So confiscating my money as a petitioner who is the wife of the accused, that is I have challenged my lord.
And the amount has been deposited on 14/11/2018 is that during the period of fraud and found that lakhs of rupees have been committed fraud by his husband, and the amount has been deposited by himself in the particular account. So because of investigation found that this particular fraud amount is deposited there, that's why it is freeze. It is under the investigation.
No. If she needs it for her medical needs, where have you made out this case that you need it for medical needs?
Yes, nothing is being given.
Where have you pleaded this before the learned single judge?
My lord, I have preferred this matter before a single judge, and with this,
have you pleaded that in your writ petition? Shows paragraph where you in the writ petition you have taken this pleading.
Yes. even if I request, my lord, if you will see the order of 23/12/2022, already learned single judge has mentioned my submission at para 4 in respect in the fourth line in this respect it is submitted that there are no provision under the Public Accountants Default Act 1850 mandating confiscation of the movable and immovable properties of the offender.
Sir, this is not the question, sir.
Yes, sir.
The legal necessity to withdraw that amount, where have you pleaded in your writ petition?
Page 5, para 8. That the appellant most humbly submits that during the month of February 2020, the appellant suffered from various health conditions, including gynecology problem, for which treatment was recommended. Therefore, in order to meet the expenses, the appellant approached the opposite party number 3 to close the TD accounts and pay the amount.
Now, have you substantiated this averment with any document?
No, my lord.
Then, and we are in 2023, probably that contingency doesn't arise anymore.
My lord, I have made several representations to Superintendent Post Office. I filed one writ petition taking a direction that they have to consider my representation. And in the while discharging the representation, they have rejected my claim. And I filed another petition before single judge. Honorable single judge, filed order dated 23rd December 2022, rejected it. And the ground opposite party has taken CRPC section 102. What is the duty of a police officer? And secondly, I may draw your attention to, my lord, page 9A of the order. In the case of Tista Atul Setalbhad, the state of Gujarat has observed that when the accused as a public officer has committed any fraud, the bank of the accused or any of his relation is property within the meaning of section 102 of the CRPC, and police officer in course of investigation can seize or prohibit the operation. Similarly, B is regarding section 102 of CRPC. And page 10, Honorable single judge of his own referred two decisions, neither it is submitted by petitioner or by the respondent, page 10 and page 11. And he has substantiated that I am not entitled for this withdrawal.
What happened in the disciplinary proceedings?
It is going on, my.
How can it keep going on and on, sir? Bring that to an end someday.
Once a fraud has been committed by any officials in postal, it is a matter of going on the investing one by one. Suppose first year has committed some fraud, then found the second audit and it was found as a fraud. Then third year is some fraud. Whatever coming, we have to make a charge sheet in that regard. This fraud was committed, it is admitted, my lord. That's why he has come to the High Court. My honorable single judge passed an order, you reconsider the representation. The representation considered at Annexure 4, his annex, my lord. This representation was disposed by the authority. Yes, Annexure 4, page 46.
No, to the writ petition you mean?
Writ petition, yes. Sorry. This page 46, this regional order is passed by the superintendent, explaining therein that such and such committees in fraud is committed. According to PAD Act 1850, this account can be
point is
confiscated by this court.
So these inquiries will never come to an end, your disciplinary inquiry.
Well, definitely it will come to end, my lord.
No compulsion to complete it.
No, my lord. They are bound to complete it.
What stage is it? When will it get completed?
My lord, let's make keep it to next week. I'll get the instruction.
Mr. Padi needs time to inform the court what the present stage of the disciplinary inquiry instituted against the petitioner's husband is. Because the petitioner is not facing any inquiry, sir.
No, only that the amount has been deposited in his R account. Only this. All otherwise,
at his request, an affidavit be filed explaining the status. List on 2nd May.
Acknowledge 58.
Bobita Sahu is appearing with Lordship may reflect.
Yes.
In this case, the defects have been removed yesterday. Your Lordship may kindly hear the appeal, my lord. The order of the Honorable Single Judge dated 20th January 2023 is under challenge. Now, before going to the impugn order, certain facts I wanted to place before your Lordship, my lord. Here, the Eco Bank is the appellant. It suffered an award under the Arbitration Act, my lord. That was challenged before the District Judge Sundargarh under Section 34 petition. My lord, may kindly see page 54. There, the respondent took the plea that because of an exclusion clause in the agreement, the District Judge Sundargarh does not have the jurisdiction to decide it, my lord. Thereafter, what happened? The District Judge Sundargarh, my lord, passed an order saying he does not have jurisdiction but affirmed it on merits. That was challenged before the Honorable Single Judge under Section 37. That order was set aside, my lord. The 31/3/2022 order of the District Judge Sundargarh was set aside. Thereafter, my lord, what the respondent did, he filed a petition before the District Judge Sundargarh in the disposed of matter saying that you delete certain paragraphs of the judgment you have filed. That was pending. Thereafter, in the present writ petition, the order which is under challenge, he sought for a direction for its disposal, which has been allowed on the first date without hearing me. My lord, it is a procedure unknown in law. Once a 34 application, his final order is passed and set aside under Section 37, how a petition will lie?
What has happened pursuant to that order, impugn order? Nothing has happened.
My lord, now pursuant to that, District Judge Sundargarh is
all right. You say notice.
Yes, in this case, my lord, I have instructions to appear on behalf of the respondent.
What is this procedure? Once the matter is over in the district judge, we're supposed to file an application.
Exactly, my lord, I want to point out because my lord.
If you're unhappy with that order, the district judge file an appeal.
No, my lord, not question on that. Question is not like that. May I submit only three sentences. One very important point is that, my lords, the award was of the year 2010, my lords. The bank filed this 34 petition before the Sundargarh court. In Sundargarh court, we raised an objection and an interim objection that is not maintainable. Then the Sundargarh court must held that it is maintainable before the Sundargarh court. This matter was not brought to the notice of the Honorable Court while the matter was taken up for final hearing. That is how this order. Thereafter, my lord, ultimately this case was rejected. No, this court has no jurisdiction. And thereafter, my learned friend has prepared, the bank has prepared a petition before the Honorable Court. Honorable Court has not set aside. It only says that you go for a clarification.
1 minute. What is this? He has not come to the High Court, sir. You have come to the High Court.
No. My learned friend has come to the High Court.
No.
My lord, may kindly see page 77.
Just a minute. But probably
just come to this page 113. Come to page 113.
I have not got by this petition.
You take my copy.
Yes, madam.
Come to page 113.
That is 113, my lords.
He has come to the High Court or you have come to the High Court?
That 113, my lords. 113, sorry, my lord. 112 to 113.
See, the writ petition starts at page 77.
No, just 113.
Who has come to the High Court?
That exactly, but this I have come to High Court.
Without understanding the question, you're going on saying, no, he has come to the High Court.
No, I have not gone through that much with due humility.
You should know why he is here in appeal.
Yes, but
he is here in appeal. He's come against an order in a writ petition.
Yes, madam.
You don't even know. You have started appearing for some party. You don't even know whether that party came to the High Court. He came to the High Court.
After that, I beg apology. My lord, excuse me that.
No, you're ready to correct the two of us here as if we don't know what we are reading.
So sorry, my lord, we do humility, my lord, I beg apology. Now, my lord, may I explain a few things? If my lord will permit me.
You have all the permission, sir. Only request to you is please make correct statements.
Exactly, man.
All right.
Exactly, man. Only now,
And don't get so busy correcting us without even having paper book, without knowing the facts.
Exactly, man. That's a mistake in my part, madam. That's a mistake. Obviously, that's a mistake in my part, madam. I beg apology for that. But may I submit? What happened? And the district court rejected the petition. Earlier in interim application allowed that yes, no, this petition is maintainable. 34 petition is maintainable before the Sundargarh court. Subsequently rejected it. Against that, the bank has come before the Honorable High Court. In section 37. The 37 order, my lord, that is important, madam. The 37 order, well, it's kind of a class of 37 order, my lord.
At page 77, my lord. May kindly see. I am sorry, my lord. It's at page 74.
74.
Kindly see, my lord. 37 order set aside the 34 order. That does not survive.
74.
He files a petition for deletion of certain paragraphs of the order which has been in appeal set aside by the Honorable High Court.
May be permitted, my lord, to just place few lines.
Procedure, my lord, unknown in law under a section 34.
If that is so, my lord, I am the last man to accept the order.
Some order is passed. The final order is passed. My lord, once the final order is passed, can he now go back to the interim order and say the final order has to be corrected? Once the final order has been set aside under petition under section 37. He should have gone to Supreme Court, my lord, saying all these things.
Permitted to place few lines of that particular judgment.
And on the first day, the single judge allows it, my lord. I'm sorry.
I mean, permitted, please. It's kind of a class to paragraph 5. That operation portion of the. It has been ascertained from the party that challenge to the award was filed within the time prescribed under section 34. Appellant appears to be covered by the declaration of the law made on such and such. It follows, well, then very important is that it follows, appellant is entitled to clarification in respect of the impugned order to the effect that it cannot be relied upon as having decided any question on merit of challenge to the award. This award will not prevent the respondent from urging the same and other points in the challenging subsequent mounted by the appellant and in the court having jurisdiction.
Subsequent, my lord.
Subsequent. That what the Honorable Court said, you go for a clarification. They have not prepared any clarification.
Sorry, sir.
So that one challenge, my lord. My lord, two issues were there. Section 14, the Honorable Judge asked that, well, that is covered by a judgment. If a court does not have jurisdiction, I will argue that. The second point was, because the Sundargarh decision said, I don't have jurisdiction, but I confirm the award and merits.
Probably.
Para 6 is important, sir. With the above clarification.
Amounting to violation of the impugned order, the appeal is disposed of.
Amounting to variation.
Sorry, amounting to variation of the impugned order, the appeal is disposed of. So now the appeal is disposed of. Thereafter, my lord, what happened? My learned friend preferred a petition before the district court Sambalpur.
Correct.
Then the Sambalpur court said that I have no jurisdiction.
No, my lord, Sambalpur did not say. What happened, my lord? When the lordship passed the batch of matters saying that the commercial court would have jurisdiction, and that was affirmed by the Supreme Court in JC case, in the intermediate period, filed before 34 there, because we were not sure about the jurisdictional clause. Now, once this order has been passed by the Supreme Court affirming the lordship judgment, we have withdrawn to file before commercial court. I have got those judgments with me.
Commercial court where?
Sambalpur, my lord. Now, commercial court, that time you are aware that intermediate period was there. Your lordship judgments are with me.
So where was the question?
How
you filing another application in Sundargarh court? Why did you?
I filed application before the Sundargarh court only to bring the notice, my lord, this particular order. That order, the honorable court, the learned court passed earlier, holding that the court has jurisdiction. That was not brought to the notice of the honorable.
Please.
While dispatching of.
No questions.
I'm
completely misconceived, sir. Completely misconceived. Completely misconceived.
So now question is, my lords, what will happen? I'll kindly visualize one thing. In the year, my lords, 2011, they filed this petition before the Sundargarh court. 34 petition. But 34 petition is disposed of now. Now they will go, they have gone to Sambalpur court after the order passed.
Yes.
And by that time, my lord, they could have preferred it before the commercial court because by that time the judgment has come before, my lords. The judgment has,
all that is more recent, sir. The judgment of this court was just beginning of.
That is judgment. My lords have passed that judgment. My lords,
where was the question of your going back to that Sundargarh court? I don't understand at all.
Stage again, my lord.
Where was the question, sir?
Meeting certain paragraphs of the 34 judgment, my lord, after being set aside in 37.
And how did it prejudice you?
Well,
how does it prejudice you?
It prejudices me in the sense, my lord.
At all, sir.
It
prejudices you. It's an order in your favor.
Kindly bear with me for 1 minute. It prejudices me.
His challenge, the Sundargarh court has been thrown out saying, I don't have jurisdiction, and that is prejudicing you.
No,
What are you saying?
No, my lords, I'm not on their, my lords.
Then where's the question? You are going back to that Sundargarh court at all?
My humble concern, that will be of some help to him, but that will not help to me. Well, because of the fact that whenever they will go, they will not be having petition.
You don't want any challenge to the award, is it?
No. Not that, my lords. Let them, they could have challenged it before the appropriate court, my lords.
I think it's all totally misconceived. It's all totally misconceived. Well, you say the challenge in the present appeal is to an order dated
20th January 23.
20th January 2023.
Passed by the
learned single judge.
WPC number 54 of
Petition Civil 54 of 2023. With directions to the learned district judge Chandragarh to dispose of an application stated to have been filed by the respondent herein in a disposed of matter within a period of 2 months. Paragraph. The background facts are that the present appellant, that is the UCO Bank Sambalpur, suffered an arbitration award against itself in a claim filed by the respondent, Sangam Keshari Kuntia. Full stop. Initially, UCO Bank challenged that award under Section 34 of the Arbitration Conciliation Act before the District Judge Sundargarh by filing ARBP number 13 of 2010. Suffered an award dated 11th August 2010. All right. Paragraph. Initially, a challenge made to the jurisdiction of the District Court Sundargarh was negatived by the district judge by an order dated, which was that first order, sir?
29/8/2011.
29/8/2011. Stop. Nevertheless, when the matter was taken up for final hearing, the district judge Sundargarh accepted the plea of the present appellant. Accepted the plea that he did not have jurisdiction. Stop. Nevertheless, by that final order dated 31st March 2022, the district judge proceeded to discuss the merits of the award and dismissed ARBP number 13 of 2010, both on the ground of jurisdiction as well as merits. Paragraph. The present appellant then came before this court with a petition under Section 37 of the Act, aggrieved to the extent that while rejecting the petition on the ground of jurisdiction, the learned district judge Sundargarh ought not to have discussed the merits of the matter. Paragraph. This plea of the present appellant was accepted by the learned single judge, who disposed of arbitration appeal number 29 of 2022 by the order dated 27 June 2022, clarifying that the district judge Sundargarh should not be held to have rejected on merits the challenge by the present appellant to the award. Paragraph. Following the above order dated 27 June 2022, the present appellant initially filed the Section 34 petition before the district judge Sambalpur. Full stop. It is now clarified by Mr. Subrat Mishra, learned counsel for the appellant, that after the judgment of this court, just give us both judgments.
First is my lord's judgment, second is the lord's judgment affirmed by the honorable apex.
Sir, all this is reported, sir.
No, the second one I have given reported. First one, I'm sorry, this is unreported one I have given.
Unreported?
No, I have given the unreported one.
Okay. Judgment of this court. Yeah, it's there.
Supreme Court judgment, I have given the report in
Right.
citation.
After the judgment of this court in Messrs. M.G. Mohanty versus State of Orissa, 2022 SEC Online, Orissa 3833, which has been sorry, 2022 SEC Online, Orissa 1070, sorry. Which has been affirmed by the Supreme Court of India in JC Housing Private Limited versus Registrar General, Orissa High Court, 2023 1 SC 549, the appellant has withdrawn its petition before the District Judge Sambalpur for filing it before the Commercial Court.
Yes, madam, commercial.
Paragraph. In the meanwhile, it appears that the respondent again went before the District Judge Sundargarh with an application in the disposed of arbitration petition number 13 of 2010, purportedly for clarification. Full stop. It is confirmed by Mr. Dayananda Mahapatra, learned counsel appearing for the respondent, that the attempt by the respondent was to bring to the notice of the District Judge Sundargarh that he had already rejected the challenge to his own jurisdiction by an earlier order of what was that 2008, which is the date order
or the earlier order dated Miller's 2011.
2011.
29.
Give me my copy, I'll show it.
Okay, put the dash.
29, 8, 2011. 29, 8, 2011.
29, 8, 2011.
My lord, 29, 8, 2011.
Full stop. When the said court did not decide the said application, respondent filed writ petition civil 54 of 2023 in this court with a prayer that the District Judge Sundargarh should dispose of the said application. Full stop. It is paragraph. It is seen from the impugned order that on the very first date, without notice to the
My lord, I appeared on that very date is not disposed of.
On the very first date, the learned single judge has disposed of the said writ petition, issuing the direction as prayed for by the respondent. Paragraph. This court has heard the submissions of Mr. Subhath Mishra, learned counsel for the petitioner, and Mr. Dayananda Mahapatra, learned counsel for the respondent. Paragraph. The procedure adopted by the respondent of going before the learned District Judge Sundargarh, who has already decided that he does not have jurisdiction to entertain arbitration petition number 13 of 2010, and which order has been accepted by the respondent, since in any way did not challenge the final judgment of the District Judge Sundargarh, is unknown to law. Full stop. Further, after the learned single judge of this court passed an order dated 27 June 2022, in the presence of counsel for the respondent, in arbitration appeal number 29 of 2022, clarifying that the above order of the District Judge Sundargarh dated 31st March 2022 should not be held to have decided the issue on merits, and confirming that he lacked the jurisdiction that court lacked the jurisdiction to decide the challenge to the award under section 34 of the Act, there was no question of the respondent going back before the District Judge Sundargarh with any application whatsoever. Full stop. And yet the respondent, within a few days of the aforementioned order dated 27 June 2022, went with an application before the District Judge Sundargarh on 15 July 2022, purportedly seeking single quotes clarification, unquote, full stop. In the considered view of the court, such an application was wholly misconceived in law, and there was no question of the district judge Sundargarh entertaining such an application at all. Full stop. Consequently, the impugned order of the learned single judge directing the district judge to consider such application, much less in a time-bound manner, cannot be sustained in law. Full stop. The impugned judgment is accordingly set aside. The writ appeal is allowed,
Obliged, my lord.
but in the circumstances with no other cause.
Urgent copy.
Yes.
Only thing, my lords, may I point out?
By virtue of this order, the application filed by the respondent
My lord.
before the learned district judge Sundargarh should be taken to be dismissed. Full stop. A copy of this order be communicated forthwith to the district judge Sundargarh to enable him to pass the appropriate order in the said application. Right.
Obliged, my lord. Urgent copy.
Right.
Item number 59.
My lords, may I only point out one thing, my lords? Fact remains, my lord's judgment about that the commercial court, maintainability of proceeding before the commercial court. I think my lords passed that judgment in the month of April. My learned friend filed this petition thereafter.
Yes, because the Supreme Court confirmed it only much later in January.
Yes,
Supreme Court
in the first page, your lordships, that has been reflected.
Everybody had gone to the Supreme Court against
Of course, perhaps I mean, to pick up fact remains, my lord, the honored single judge has given me the liberty to raise all those points.
Obviously. Right.
Item 59.
As item 59 pertains to, my lords, that vocational training center in Baranga. My lords had directed to file an affidavit. We have filed the affidavit. The clarification that was sought was with regard to whether there was a proposal for upgradation. So the proposal has been accepted and the construction has already commenced. We have given photographs.
And let me just point out, make a submission on the prayers. I want to draw your lordship's attention to the prayers. There were two prayers. One is, further be pleased to direct the opposite parties to take all possible prompt steps to revive, expand and develop vocational training center for physically handicapped persons of Baranga. That's they are doing. Because they are making upgradation, renovation of this thing. The second prayer is that this honorable court may be kind enough to direct the opposite parties to take immediate steps for construction of special ITI/ITC for a physically handicapped person of Baranga. Actually, earlier, they made an allotment of 1 crore rupees for this purpose. They have not given any reply to
So
that.
your affidavit is silent on that. All right. You say there's an affidavit dated 16 February 2023 has been placed before the court. Full stop. In it, the district social security officer in the office of the collector Cuttack states that the proposal for upgrading the vocational training center into a resource center for persons with disabilities has been approved and construction work has already commenced. The stop photograph of the ongoing construction is enclosed. Paragraph. Counsel for the petitioner points out that there is one more prayer in the present writ petition, which is that the opposite parties should take steps for construction of single quote special ITI/ITC for physically handicapped persons of Barang, unquote. On this aspect, it is not clear whether there is any decision taken by the government. Full stop. The court accordingly directs that a supplementary affidavit be filed specific to this issue before the next date. List on. Second May.
May I please, Your Lordship? Here, my lords, an affidavit has been filed by the state.
16.
Wherein they have indicated that they are taking steps for recruitment. But if Your Lordship sees, the timelines have not been provided as to when they intend to do it and to complete this recruitment, my lord.
No.
And in the absence of such a timeline, my lord, by the time they make the fill up the vacancies, the force would already be overburdened.
No, my lord, your lordship may see my affidavit phase 2. The first paragraph we have thereafter the written exam will be conducted. The tender process of recruitment is likely to be completed by April 2023.
That's for constable only.
And so far, if in
No, this you're meeting this deadline, last date for submission of online, was that done?
21/1/2023.
That's been done?
Yes.
Okay.
And that will be completed by April 2023.
What about the remaining CPOI?
What happens, my lord? Normally, those candidates who appear for constables, they also appear for CPIs. After completion of this process, again, we will start process for the recruitment of CPIs. After April 2023, we will again start process.
No, but...
And in respect of others, my lord, we are taking promotion from time to time.
No. But you have to give breakup, sir. ASI, SI and all are very important posts.
No, ASI, my lord,
there's no timeline.
In ASI, you'll also see that already, you'll also see assistant page 4. There is no vacancy as on 31/12/2022.
No. By now there will be, sir.
Because why there is no vacancy, my lord, what has happened, my lord? In a number, some cases were filed before this honorable court, and a list is prepared around 2,000 odd, my lord. There, your lordship are directed to adjust that list, and till that list is again, no further recruitment process will be.
No. Aren't there vacancies already in ASI this year?
That is, your lordship, I have taken that till 31st December 2022.
Correct. But we are now almost end February.
Normally, we are taking the vacancy. So far as other vacancy, if that will be filled up, my lord.
Okay, let's go to SI now. 1,415 posts.
Vacancy as on 31/12/1415, my lord.
No, actually, you have not even calculated the
because the affidavit was filed on 6th February, my lord. So we have taken into account till 31st December.
No, that's fine. But you're not given any timeline for filling it up.
My lord, in respect of SI, we have not given the timeline that I will take in respect of that SI. In respect of others, my lord, we have given the timeline.
No, only for constable you've given. ASI also, ASI anyway you say vacancies are not there.
ASI, my lord, no vacancies.
There are two kinds of SIs, ordinary SI and SI armed.
Well.
And an SI armed, you have 284 vacancies.
Even Havildar also timeline has not been provided.
But they say Havildar after constable because they can also apply for Havildar. So that's why they don't give a timeline for Havildar.
And if your lordship sees at page 5, your lordship will find 2018 vacancies are being filled up in 22, 19 in 23, 21 no date timeline is there.
That's what.
And this will go on having cascading effect.
Yeah. So SI, he says he'll file an affidavit. SI armed also you have to file an affidavit. Inspector 134.
Well,
again, no details given, sir. DSP 57.
My lords may see the next page. So far as Inspector Mail. 134 vacancy as on 31/12/2022 was 134. And we have taken promotion in 2022 134.
How are you going to fill up? When are you going to fill up? That is the problem. There's nothing. It's silent on that.
All the posts, 134 posts have been filled up by promotion, my lord, in 2022.
No, just see. Promotion for the year 2023 would be taken up at a later date. That's it.
Looking at page 8,
that's right. He said at a later date. There's no time. What he's saying is there's no
yes, I'll give the in my space.
You say a supplementary affidavit, an affidavit has been filed. An affidavit 6th February 2023 has been filed. by the Additional Superintendent of Police pursuant to the order passed by this court on 10 January 2023. As far as the post of constable concerned, as on 31st December 2022, 4790 vacancies existed. The process of conducting an open competitive exam has already been initiated by the State Selection Board. It is expected that, according to the affidavit, the entire process is likely to be completed by April 2023. Paragraph. As regards the 546 vacancies of single quotes Sepoy and Battalion Constable, unquote, Mr. Kuntia states that the filling up of those vacancies will be taken up after conclusion of the selection of constables, since the persons who applied for the post of constable would also be eligible to apply for Sepoy and Battalion Constable. Full stop. Nevertheless, in anticipation of the conclusion of the process of selection of constables by end of April 2023, a timetable can certainly be drawn up, even as of today, for holding the selection for the posts of Sepoy and Battalion Constable. Paragraph. Likewise, posts which have to be filled up by promotion, like that of the Havildar and Assistant Sub-Inspector, should also be done in a time-bound manner. The affidavit is silent on any timelines for filling up of these vacancies by promotion. Full stop. Paragraph. Turning to the posts of SI of police, to be filled up both by way of direct recruitment and promotion. The SI of police bracket armed, the Inspector of Police and Inspector of Police bracket armed, the DSP and additional SP. Although there are vacancies, the definite timelines for filling them up have not been indicated. This stay of DGP gradation list, DSP gradation list.
That was stayed, my lord. Subsequently, it has been vacated.
Vacated now. Mr. Kunti acknowledges that the stay earlier granted of the DSP gradation list has since been vacated. Paragraph. In the circumstances, the court directs that and a supplementary affidavit be filed by the state, setting out the precise timelines for completion of the process of filling up of the vacancies in the various posts as noted herein before.
Armed, as far as SI armed is concerned, they have notified only up to 2018.
I know.
The figures beyond that are not given.
The said affidavit be filed on or before 1st May 2023. Or you say on or before 15th June 2023. Stop. List on 27 June.
But it's, I had filed a report on the 2nd of January 2020. Now, para 4, 5, and 7, my lords, if I may draw your lordship's attention to, this is in line with the judgment of the Honorable Apex Court, where the state is required to do certain compliances. And this becomes all the more relevant for the damage caused to public property. They have to have guidelines for that. Now, let them file an affidavit as to what steps they have taken with regard to the report in respect of para 4, 5, and 7 of the report, Amicus. This report I had filed on the 2nd of January 2020.
Right. The learned, Mr. Gautam Mukherjee, learned amicus curiae, has drawn attention to paras 4,
5, and 7.
Para 5 and 7 of the note submitted by him in this case on 2nd January 2020, sorry. Highlighting the responsibility of the state government to recoup the losses of the damages during the holding of hartals, bracket bunds, stroke bunds to demonstrations, and for the directions issued by the Supreme Court of India in the case of destruction of public and private properties was the state of Andhra Pradesh, 2009, 5 SCC 212. Stop. Since the affidavit filed by the state government is silent on this aspect, the supplementary affidavit as directed by this court will also include the response of the state government to the above suggestions in the report of the amicus curiae. To the suggestions made by the amicus curiae in the report referred to hereinbefore.
Item number 61.
None appears.
No.
This Mr. Normas.
Item 62.
May I please, my lord? My lord, here challenging the illegal construction of wall in between the high tide line of the sea, in between the road. That has been challenged. Now the issue to be decided by this honorable court is whether the Central Empower Committee of the Supreme Court is authorized to permit for any type of construction inside the sanctuary or the eco-sensitive zone headed by the collector. I have filed in my rejoinder affidavit given 2 public documents wherein it clearly shows that the construction is inside the sanctuary. They have to file the reply. Last order is at 17/8/2021.
My lords, I have been served with the counter of the union government. Where, my lords, they have taken a stand which is at variance with the state government. So I'd like to require some time to file a reply to the affidavit of the union.
Mr. Mahanti, learned.
My lord, one humble submission. If they're asking for time, my lord, I have filed an IA. That IA is IA number 6995 of 2021. There I have prayed for a direction to appoint an advocate commissioner for local inspection of the ongoing wall construction. Yeah, that has completed. That the petitioner will bear the cost, my lord. If my IA will be allowed, I will be highly obliged, my lord. Because that is sort out the problem, whether it is inside the sanctuary or not. If it is not inside the sanctuary, I don't have any case. But if it is inside the sanctuary, it is the Central Empower Committee of the Supreme Court to grant permission.
Oh, it can go. Why should the state government not place that fact before us? Why do we need an advocate commissioner for that?
2 years had gone.
We can ask even the Tahsildar to place that report.
Yes.
Yes, my lords.
We don't need a commissioner.
My lord, my lord, may I suggest, my lord, we have filed the detailed affidavit. Let the status of the copy. Let them give a reply because specific averment taken para 5, 6, 7, 8 is required to file the affidavit by the court.
That's what he's asking.
Yes,
Yes, say an affidavit has been filed with the central government. Full stop. Mr. Mahanti, learned. additional standing counsel for the state seeks and is granted 4 weeks time to respond to the said affidavit of the central government.
Let them serve a copy of that counter to us, my lord. We have not served with the copy of the counter.
Maybe survey also copy.
Copies of the counter be served on counsel for the other parties.
Central government.
List on 28 June. No, 27 June. 27 June. You can have it on 22nd June, I think.
22nd.
Yeah, 22nd June. All right.
22nd June, my lord.
Yes.
Yes, obliged.
IA number
Along with Mr.
6995. The petitioner prays for appointment of an advocate commissioner to visit the protected area of the Balukand Konarak Wildlife Sanctuary to inform the court whether the road in question is inside the sanctuary or not. Question mark. Since the Tahsildar is already present before this court and is represented by the ASC, the court sees no reason why, if any doubt arises as to the exact location of the road, the Tahsildar should not be asked to give a report. Stop. The application is therefore not entertained and is disposed of as such.
Item 63.
No, item 63. Just now, my lord, they served the copy of the affidavit, my lord.
Compliance affidavit, and I have
Just now, my lord, given the
counter affidavit filed by the opposite party state has been served on counsel of the petitioner who seeks time to file a rejoinder. The counsel of the petitioner is permitted to respond to the said affidavit before the next day. Right in the beginning, you see an affidavit dated 21st February 2023 by the Deputy Director of Estates, General Administration and Public Grievance Department, Government of Orissa. The said affidavit purports to give the net present values and economic value of the trees that would be marked for removal for the purpose of construction of the MLA colony. So, the counsel of the petitioner is permitted to respond to this affidavit also before the next date. List on. I think this also can be 22nd June.
22nd June. Obliged.
Item note 64.
64 and 65 mailers are covered by your lordship judgment. That trade certificate is a wonderful judgment. I must.
That's all. No, who's for the other
mailers? Yesterday night I was going
I don't think they will agree with you on that.
My lord, why I say it reminded me a book written by Upani, Tax Jurisprudence.
Right.
Lordship must have read it. They are the incidents of taxes.
Correct, correct.
Three things: object of the tax, incidents, and the mechanism.
Right.
Mr. Uppani was the member of the Income Tax Appellate Tribunal. He retired as a vice president. And your lordship, in this judgment, I found para 47, relying on Goodyear tire versus State of Haryana, 1990 Supreme Court. And the other day when I was arguing, my lords, regarding the entry tax, I brought to the notice of this honorable court but Justice Bhagwati's minority view, tax due and the liability and the payment, when it is levied and when it is payable, due and payable. So, my lords, para 56, 57, lordship have quashed the
Both these petitions are disposed of, we'll say, in terms of this judgment.
Yes, yes. Para 2 and 3 has to be quashed, my lord, the demand notice. No, you are not. Mr. Misra is always, he also wants to grab the motor vehicle fees. This is not yours.
No, Mr. Behra, Mr. Prabhakar
Mr. Behra is, I think, copy has long been given.
See, he might produce a Supreme Court order staying this judgment. So you better wait. He'll pass it over.
Matters pass over. Again, it will be in the month of August.
No. Passover here, it will be called down. We'll just pass it over once. We don't know. They may have filed an appeal. My sense is they would have filed an SLP, definitely. All right.
All right. Item 66.
In the last occasion on 9/11/2022, your lordship directed for instruction to the standing council of the service department member. And however the case remains is that member. The assessee is a GST dealer and he has not paid tax for 2 quarters, for 1 quarter, for which he has paid it belatedly from the credit ledger. And that amount they have disputed, they might have paid it from the cash ledger. But they have paid them entire amount from his credit ledger. In my written note of
submission, this is not covered by that circular.
It is covered by the circular.
Your lordship, on the last
so the attachment may be kindly lifted.
Your lordship, on the last occasion, your lordship has directed to file counter. But here, your lordship, however, your lordship, I have not received the instruction, but your lordship, prima facie on the face of the record, your lordship, and as well as the circular, your lordship can set aside this assessment to the assessing officer. Because why I'm saying so, whether due to that non-payment and the payment from the credit ledger, whether the interest and penalty, that portion, because the circular itself says those portion cannot be adjusted from the credit ledger so far as that payment. So whether it is due to that payment only or not, it is to the assessing officer to verify. So the assessing officer to redo the assessment pursuant to this circular.
In page 10, annexure 1, the assessing officer has stated that it appears that you have made payment of tax, interest and penalty by debiting from your credit ledger and partly by debiting from a cash ledger. But that is their observation, own observation.
Your lordship, the circular says,
I have already paid. If it says
the circular says,
to that extent only it is covered.
Your lordship, the circular says that the output tax is to be paid. And so far as the interest and penalty, it cannot be adjusted from the credit ledger. The circular says it cannot be used for making payment of any interest, penalty, fees, or any other amount.
Let it go back.
No, attachment in the packet, man.
Yeah, all right. You see, where is that circular, sir?
Circular is there.
Questioning an order dated 22nd July 2021. Issued by the CT and GST officer, Barville Circle. Sorry, Barbie Circle Judge Board. Barville Circle Judge Board. Under Section 73 of the OGST Act. Raising a demand for tax, but interest and penalty for the tax period March 2018, both under CGST and SGST Act. in the sum of rupees 845,074, the present petition has been filed. We'll stop the above. Order was preceded by a show cause notice dated 29th April 2021, in which it was alleged that inasmuch as the amount of tax, interest and penalty was made by debiting the petitioner's electronic cash ledger. By the electronic credit ledger. It was in contravention of section 41 bracket 2 and 49 bracket 3, read with rule 85 of the OHGST rules. Paragraph. Today, Mr. Patnaik has placed, learned counsel of the petitioner has placed before the court the copy of the circular dated 6 July 2022, issued by the GST Policy Wing, bracket, Central Board of Indirect Taxes and Customs, Department of Revenue, Government of India, permitting payment of taxes by using of the electronic credit ledger. Full stop. In that view of the matter, while setting aside the impugned order dated 22nd July 2021, court remands the matter to the CP and GST officer, Barbel Circle, Jajpur, for a fresh computation of the outstanding demand after accepting the payment of interest and penalty, by accepting the payment of tax using the ECL.
Well, I have already paid the tax. I have already annexed.
That's it. That's it.
Attachment
by accepting, yeah. Accordingly, the attachment of the petitioner's bank accounts by the order dated.
Annex 3, measure.
By the letter dated 17th
January 2020.
Addressed to the petitioner's bankers shall stand quashed.
Your Lordship, to let the petitioner, Your Lordship, submit its submission against that show cause, because prior to order,
this order goes, the show cause is still there.
So
we can have.
Your Lordship,
the matter will now be listed before the CT and GST officer, Barbel Circle, Jajpur, on 8th May 2023. Full stop. The petitioner will reply to the SCN dated 29th April 2021 afresh on or before 3rd April 2023.
Gratefully.
A fresh order will be passed by the CT and GST officer in accordance with law. Right.
Yeah.
Item number 67.
Your Lordship, item 67, some more time, Your Lordship, for filing of counter.
Correct. Counsel, the department seeks and is granted 8 weeks time to file replies. Reply to the petition, rejoinder before the next date. There's an interim order.
Yes, my lord. Interim order may continue.
Interim order to continue. List on. July.
Let's say item 68, the next item is the same. I request my law and friend to serve extra copies, Your Lordship.
Right. Mr. Monty. So 58.
Interim order to continue.
Again, reply within same date. Interim order to continue. Okay.
Item 69.
Item 69, my lord's infructuous.
Infructuous disposed to be. Both matters.
Item 70.
Met legal lordship on behalf of Mr. Manti, matter is infructuous.
All right. Infructuous disposed.
Okay.
Item 71.
Item 71, my lords, all the matters have been infectious only, my lords, writ petition number 1254 of 2019. It has been already been disposed of, my lord. By order dated 7/7/2018.
All right.
It has been wrongly mentioned on the list.
Wrongly listed.
All right. 1254, just simply say wrongly listed since it is already disposed of. The other matters you say disposed of is infractuous.
Item 72.
Item
73, Your Lordship, I am appearing for the State Pollution Control Board. For its time may be given for filing count.
They have not
Let's see what
filed
he
counter.
says.
They have not filed the counter.
Oh,
Direct.
counsel appearing for the State Pollution Control Board seeks and is granted 8 weeks time to file a reply as a last chance. Rejoined before the next day. Is there an interim order?
I want interim prayer. Status quo to be maintained because interim notice was issued. They have not filed in counter.
Since 21, sir, there's been no.
No, because my license will be renewed from 31st, from 1st April. They may not renew because of pendency. They have not done anything.
No. The pendency of this petition, it is clarified that the pendency of this petition will not come in the way of the petitioner's request for renewal of license being considered in accordance with.
In accordance with law. Yes.
We are applying to open over 4 also.
List on. July. 18 July.
Item 73 also same.
Same.
Item note 74.
74, my lords. Counter the. He says
We are filing a reply given by the counter given by him.
But there is a out of settlement because we have also, I am also informed that the parties are having a talk of out of court settlement. That will be fine if that is done, Your Lordship.
All right.
Yes.
Mr. N.K. Mishral and senior counsel appearing for the appellant states that the parties are in talks for settlement. List on.
Short date.
19 July. 19 July.
19 July.
Yes.
Yes, ma'am.
All right.
Item 75.
My lord, item 75. I praise short adjournment. My lord, today, due to mild throat infection, I am not able to.
Counsel for the appellant stated me unwell.
Any day.
19 July. 19 July. Right.
Let's see.
19 July. Item 76.
For 76, Your Lordship's last direction has been complied with.
All right.
In 76, I appeared for the
matter will be taken up for hearing, my lord.
76, I am appearing for the opposite party. Respondent. And my information is they have not complied. I let them serve a copy of what they have complied so that I can give a reply.
So they are allowed to join here.
No, my lord, I have not. Your Lordship can see what was the order passed.
Yes. No, last time Your Lordship kindly see.
Page 36.
No, order. What was the order?
Yes, my lord. That is that. And otherwise also, as discussed earlier, to the acceptor, consequently, 1, 2, 3, 4th line from the top, the petitioner shall be reinstated in service with all consequential benefits as advisable to him in accordance with
probationer, my lord, he was a probationer. He was terminated because his integrity was doubtful and he was not satisfactory. Then Your Lordship directed him to reinstate. He has been reinstated in job.
My lord, let them serve me a copy that so that I can get.
He has joined. He has joined, my lord.
No.
All right. Counsel for the appellant informs the court that the respondent has been reinstated. Full stop. Counsel for the respondent, on the other hand, states that he has no information. A supplementary affidavit shall be filed by the appellant as regards compliance with the directions of this court.
Yes, my lord.
List on.
Any short possible date, my lord. Earliest possible as Your Lordship may please, my lord.
Earliest possible is 19 July.
Yes, ma'am.
All right.
And he has been paid all the dues, whatever be that.
I'll comply that. I'll get you.
But otherwise, he couldn't have engaged senior counsel like this.
No. He is more tougher than me, sir. So far the fees are concerned.
This itself shows he has received everything.
Yes.
Item 77.
Item number 77, my lord. My lord, on the last occasion, your lordship said, observe that your lordship have given a judgment on the question whether wheat bran is treated as cattle feed or not. My lord, I have got that decision, my lord. But that decision, your lordship, I am handing it over. Your lordship have given in the context of Orissa Entry Tax Act, my lord, where cattle feed was taxable item, my lord. My lord, my case is that this is the judgment, my lord. This is the judgment.
The earlier judgment is come against.
This is the judgment, my lord. Your lordship have delivered in the Entry Tax Act, where cattle feed was taxable, my lord. Cattle feed was taxable, but this is the judgment, my lord. Your lordship have delivered.
Correct.
In the context of Orissa Entry Tax Act.
Correct.
There, my lord, in that case, the single member of the tribunal, the chairman sitting as single, has treated that wheat bran is cattle feed. Cattle feed was a taxable. Your lordships have dealt with that judgment, case law, at para 11 of this judgment, my lord. My lord, in that case, my lord, 3 to 4 judgments have been given on the question of exemption matter, my lord. So by employing the exemption matters, exemption notifications applicable to cattle feed, where cattle feed is exempted and wheat bran was treated as a cattle feed, that learned single member held that wheat bran is cattle feed, so it is taxable. Your lordships have told no, that is not the case. Wheat bran cannot be called cattle feed, so it will not come within the ambit of the Entity Tax Act, so it is exempt. It is not taxable. I am dealing with just opposite, my lord. I am dealing with the Orissa Value Added Tax Act, where cattle feed is exempted item, my lord. Cattle feed is exempted, my lord. Cattle feed has been defined, my lord.
Right.
My lord, Schedule A of the Orissa Value Added Tax Act
How much homework they've done, so.
in my case, Miller, the period of assessment was from 1st April 2005 to 31st October 2005. Miller, previously, Miller, cattle feed entry 3 Miller, Schedule A, was aquatic feed, poultry feed, and cattle feed, including grass, hay, and straw, Miller. This was amended with effect from 1/7/2005. My lord, since my period of assessment was from 1/6/2005 to 31st October 2005, under section 42 at the time of assessment, the total turnover of the wheat branch, that is choker, had been given me, exempted from tax. At that time, this choker was not there, Miller, included not, but cattle feed including grass, hay, and straw. Amendment came with effect from 1/7/2005, wherein this entry was completely substituted, Miller. Not it was inserted, not that wheat bran or chocolate was inserted but added. The entry was completely substituted as aquatic feed, poultry feed, cattle feed including supplements, concentrates, additives, de-oiled cake, grass, hay, and straw, and husk of pulses, wheat and groundnut, including choker, Miller. This came into effect from 1/7/2005. So, Miller, since I had given exemption from 1st April 2005 to 31st October 2005, under section 43, Miller, notice was issued to me as the wheat bran turnover for the period from 1st April 2005 to 30th June 2005. This
1 minute. 1 minute.
With passover or first call?
First call. We'll take it at the end of the board. I think it will take some time, correct?
My lord?
It will take some time. We will take up end of the board. We will take up end of the board.
ସବୁ ସରିଲା ପରେ ନେବେ ସବୁ ସରିଲା ପରେ ନେବେ ଆଗ କେସ୍ ଗୁଡା ନେଇ ଆରେ ଜିନାଉ ଟିକେ ଜୋରରେ କହୁନ ଜିନାଉ
Okay, my lord. I have some problem, Miller, hearing. That is the problem, Miller. I could not. I am sorry for that, Miller.
Item number 78.
Here in this case, your lordship, two tax revision along with two writ petition, all are connected to each other. In this case, what happened? Your lordship, the appellant before your lordship is a government of Odisha undertaking, fully owned by government of Odisha and created by statute Odisha Bihar Excise Act, section 20 of the A of the Odisha Bihar Excise Act, which gives the petitioner the privilege to a wholesale privilege to sell liquor and country spirit throughout the state of Odisha. In this case, what happened, Your Honor? In this case, what happened? The assessment was completed under section 12(4) of the OST Act, wherein relying on an untested audit objection, the learned assessing officer has enhanced the assessment that on an allegation that the corporation has collected less excise duty, for which it's reduced the sale, and for that he has enhanced the assessment. Against that assessment order, the petitioner has filed an appeal before the appropriate appellate authority. The first appeal was rejected and assessment was confirmed. Then the petitioner has filed.
Question of law, Your Lordship, is not there in this brief, in the petition, Your Lordship.
Yes,
which one? But it's been framed.
Yes.
9 July 2018.
The question of law has already been admitted, Your Lordship.
It's here, no, Your Lordship, in my
no, just show him
petition,
the
I could not find.
1 minute. STRV 25.
Your Lordship.
Let's see the order dated 9 July.
On 9/7/2018, it has been admitted, Your
In the
Lordship.
brief, I could not find out the question.
Very long question. All the arguments are there in the question itself.
Your Lordship, actually, I could not find out from the brief, Your Lordship, because in the petition itself has not been drafted. That question of law has not been drafted, Your
Yes,
Lordship.
it has been.
You can argue without questions also. No need for framing up.
Your Lordship, can I play some other time? Your Lordship, please.
No, that's all right. You say counsel for the department seeks some time to address arguments. A written note of submissions be filed by both parties before the next date. Is there some interim order?
Yes, sure.
Interim order to continue. List on 27 September.
My lord, 27 September. Item 79.
In item 79, my lord, senior counsel, Mr. Patwala is engaged in this case, my lord. He has to be on the VC, my lord. I pray let this matter.
Maybe in some other manner. At least in the next one.
Let this matter be taken up some other day, my lord.
All right.
And in the process, the petitioner has retired.
The Supreme Court wanted an early disposal of this.
Right, my lord. And by the time it was pending, he was at the verge of retirement. On my prayer, it also fixed it early. In the meantime, he has retired. The only question will remain is terminal benefits if you will get anything. That's all.
It is stated that the respondent has superannuated. Stop. Counsel for the appellant states that the senior counsel engaged is in some difficulty today. Stop. The court notes that this is a appeal which has been remanded by the Supreme Court of India for expeditious disposal. Stop. 19 July?
That will do, Lord.
All right, 19 July.
Beg your pardon, my lord. That item number 77, what your lordship has stated that end of the board, your lordship. My lord and senior is there. Your lordship, what I pray, just now he has handed over me 5 judgment, your lordship. So that judgment, your lordship has passed. I know that judgment because I was appearing in that case so far as the Entity Tax Act is concerned. So can it be taken up some other day, your lordship? Because I have to go through all these judgments.
All right. Counsel for the department 77 needs some time to examine the judgments relied upon by learned counsel for the petitioner. Good. All right. List on 14 September.
Item number 80.
80, Your Lordship, I am filing the writ.
Your Lordship, I appear on behalf of the respondent.
Yes. Wow. We'll take it up after lunch, Mr. Ganesh.
Very well.
All right.
And 65 with
Right.
Lordship's kind permission. It was served on Bigyan Sharma, who was the then standing counsel for the transport.
So you'll have to serve it on now on the.
My lord, that will be paper cost, and also I will not get that fee. What I propose is
Just
like
say
this.
dispose of in terms of the judgment.
Yes.
All right.
May I seek one indulgence, my lords, my lords? Yeah. Can my lords hear me? Am I audible to my lords?
Yes, please.
Yeah. I want to seek one small indulgence from your lordships. Lords, I'm about to reach in the next about say 10 or 15, 20 minutes my lords, in a parted matter, my lords, where I'm on my legs in the Supreme Court. Can I come back to my lords by about 3:30? 3:30.
Standing counsel is there. He's to argue. There it's appeal.
All right, Mr. Ganesh.
I'll be very, very
we will only answer.
No, it's 64, 65. The prayers in the present petitions stand answered.
Para 55 and 56 of the judgment. That is most important. Deichi na? Mo aguru copy deichi dioda.
That in bracket, Messrs. Sushi Automotives, State of Orissa. We'll stop the present writ petitions are disposed of in the same terms.
Yes, that 29th March 2016 circular is quashed as well as the demand notice.
Yeah. In other words, the impugn instruction dated 29 March 2016 and the consequent demand notices are hereby quashed.
Right. Yeah, in the end, your lordship have refused to get the refund.
Yes.
Yes, the affidavit filed by the dealers didn't disclose to whom it has been shifted.
Correct.
So actually, in indirect tax, always the burden shifts to the consumer.
Correct.
But I have great, praise for the judgment and particularly para 43 and 47.
All right. Thank you.
Oh, no, my lord. Is my I came across that judgment. It reminded me so. Initially in the practice, I read so much, and the incidence of taxes.
Correct.
That is the basis of the tax jurisprudence. Correct. When it is levied and on whom.
Right.
It's a great thing.
Thank you. Oh, there he is, Mr. Vera. The same, it's covered by those judgment. We were only asking whether you had already filed an appeal or not.
No,
not yet.
No, he says it's covered by a lordship judgment.
That matter, I have not copy. That is why
no problem. Right.
Copy the began only.
Old matter.
Right.
Pastor matter item number 7.
Old. Sorry.
Memo was taken on record.
My lord, the earlier the matter was
Senior standing counsel speak it.
Actually, I filed a written note with judgment. Before I will place the written note and judgment, your lordship, I request your lordship to see the finding based on which revenue challenge this order. It has been quoted in appeal memo in internal page 5.
The first one, 39.
Yes, page it starts from page 4, 35, 36, and 42 and 43. That is the sum and substance of the order against which revenue challenge before lawsuit. May I place the paragraph 35, 36, and 42 and 43. Thereafter, I will go to the submission of the revenue and the judgment and written note and what is the issue in one question, what is question was framed.
All right.
Before I start, Milord, it is a fact that the assessment order was passed. He has not participated in the first proceeding. He has not filed and written. Thereafter, challenge before the appellate. There is not challenge the technicality, whether in 140D is applicable in totality, and stating therein that whether the draft assessment is approved, whether one day it is qualified under the act that it is a approved order. And second one is it was not reflected in the order of assessment and basis, and later on he has not reflected all these things. Not I am placing 35 and 36. We are unable to see any mention by the approving authority that he has perused the relevant assessment record and draft assessment order proposed to be passed by the assessing official. The assessing officer issued a letter seeking approval on 29/12/2010 and approval has been granted on 13/12/2010, and that after a passage of 1 day only. From the approval order as produced here in above, it is very much clear that approving authority, that is the additional SCIT, had not even bothered to mention that he has perused the relevant assessment record and draft assessment record for which he has granted approval under section 153D of the Act as per the mandatory requirement of the state provision of the Act. No case law has been cited by the learned CIT-DR, has not cited any case law that mentioning regarding the approval order under section 153D of the Act in the assessment order is not necessary, and circular 3/2008 dated 12/3/2008 is not applicable in the present case. There is nothing before us to show that requirement of mentioning regarding approval under section 153D of the Act in the assessment has been dispensed with. Then Lord 42 and 43 relevant. Lord.
Yes.
We clearly find that approving authority has not applied his mind to the relevant assessment order prior to granting approval to the assessing officer or passing the assessment order under section 143.3, 144 and 153 of the Act dated 30/12/2010. Further, it is also observed that from the relevant approval order dated 30/12/2010, it is vivid that the learned ACIT has not mentioned the approval order, that he has gone through the relevant assessment record, files, folder, and draft assessment order for granting approval. We also observe that the AO wrote a letter to the ACIT dated 19/29/12/2010, and reply was received on very next day, that is 30/12/2010. And very same day, the assessment order has been passed, but without mentioning that the order is being passed after obtaining approval 153D of the Act from the learned ACIT. The above noted factual metrics of the present case clearly show that the approval had been granted in a mechanical manner without applying application of mind, and thus no valid approval is granted by the learned ACIT before authorizing the AO to pass assessment order under section 143A of the Act. 153A of the Act. The requirement mandate of the section 150D of the Act has not been satisfied. Accordingly, hold that all the assessment order are vitiated and thus same are void, being bad in law. We accordingly set aside the improving order of the lower authority and quash the assessment order by allowing ground note 2 of the assessment. Now you will also see the order of the tribunal. It starts from page 67, where the approval has been
relevant para is para 36. Relevant para to shortcut the court's time.
No, I'm trying to settle, sir.
Yes.
No, let him settle. Page
67, paragraph 33, Milord. Turning page 67.
Yes.
This is a letter issued to the Assistant Commissioner. Before that, 66. I'm sorry, 66. Letter issued to the Additional Commission Income Tax Range 1 Bhubaneswar. Subject, Milord. Approval of draft order under 153 of the Act in case of so-and-so matter regarding enclosed herewith kindly find the draft order under 50 of the Act along with the assessment records in case of so-and-so for kind perusal necessary approval under 150D. Then Milord, the assessment here, everything has mentioned. Above case will be barred by limitation on 13/1/12/2010. Next page, Lord see. That is the approval order.
Correct.
Subject approval under 153D in case of so-and-so, draft order 153A, 143, 144 for the assessment so-and-so, under so-and-so in case of above mentioned. Then you also see. Please refer to the above. The draft order under so-and-so submitted by you in the above case or following assessment are hereby approved. Submit a copy of final to the official record. Therefore, my Lord, my submission is, Lord, he has perused all the records, Lord, and quantified how much the demand, and then Lord approve the order. Now you will also see the section 150D for a moment before I go into Lord other parts. Lord.
Yes.
Prior approval, the wording is, Lord, prior approval necessary for assessment in case of search or requisition. Lord.
no order of assessment or reassessment shall be passed by an assessing authority below the rank of Joint Commission in respect of each assessment year. Referring clause B of section 153A of the assessment, you refer clause B 150 except the prior approval of the Joint Commission. Providing that nothing contained section shall apply where the assessment reassessment as the case may required to be passed by the assessment with prior approval of the principal commission or commission section 1. Therefore, the wording is not that approval is necessary. In this case, my lord, clearly it is visible, my lord, that records has been submitted to the higher authority and on the administrative ground, approval has been granted. My lord. But the tribunal, my lord, by referring so many judgment of the tribunal and all these things, my lord, he has traveled and concludes that it's passed in a mechanical manner without avoiding the proper opportunity. Your lordship, I have categorically in written note, have distinguished all the judgment which are cited by the petitioner before the tribunal and the tribunal which has been referred. Your lordship, see, I'm placing in my written note all these cases. It starts from, my lord, it starts from on internal page 9 of my written note.
Yes.
Para D.
Yes.
The respondents relied upon certain decision before the ITAT, Cuttack bench Cuttack, but same are not applicable present factors. It is distinguishable fact of the case, the detail is elaborately given. The judgment of Honorable Tribunal of Mumbai, in para pain of the advocate, it is mentioned that additional CIT range 7 had asked AO to submit the draft order approval on 153D of the Act on or before 24/12/2010. However, the draft was submitted on 13/12/2010. Therefore, clearly it is not a case, as I am placing, Lord, it is not a case that the draft assessment order was passed after, Lord, some days, Lord. It is prior to assessment, approval has been given. Basing on that, hereby we left no time to analyze the issue of draft order and orders. With these comments, the draft order was approved as it was submitted. Therefore, in contrast, it is held that Mumbai Tribunal ITAT and the NRC has not applied his mind while granting approval under 50th. However, in the present, no such comments have been delivered by the additional CIT range of Bhubaneswar while according the approval. Therefore, preliminary, this issue is not covered in my case. And the order approval, later on I come to what is the approval and later on, and next, let's see the judgment Pune ITAT, Pune ITAT case, Akhil Kulamin Somiji so-and-so, under Gujarat High Court in case of Sunrise Kinless Private Limited has been rendered under different facts. In case of Akhil Kulamin Somiji, AO while framing the assessment under section 150C had failed to obtain SC approval under 153, para 3, page 7 appeal letter. Similar case, Sunrise Private Limited, AO while framing the assessment under 153 had failed to obtain necessary approval under 153D. However, in the present case, the CIT range has acquired approval in this later bearing note shown. So therefore, it is also not applicable in the fact of the case. Now, the judgment of Cuttack bench relied upon by the assessee in Sri Tarnath Chaudhary versus CIT so detailed is distinguishable fact. In para 23 of decision, it has been mentioned that London additional CIT central range had given a reminder to the AO to submit a draft orders for approval under 153 on or before 23/3/2015. However, the draft order was submitted on 26/3/2015. Thereby, was left with no time to ensure that all the points in the appraisal report, the appellate proceeding, audit, inspection, etc., have been duly taken into account, and inquiries investigation required to be made were actually made by the AO. In the end, he has also mentioned this case was never discussed with him. With this comment, the draft order was approved as required under the statute under 53. Therefore, said condition was that ITAT, that CIT had not applied his mind while granting mechanical approval under 153D. However, the present no such objection is made, mentioning the CIT range 1 was well accordingly approval. The judgment of CIT Cuttack bench, Cuttack relied the present case in Srimati Gitarani Panda versus CIT. It is distinguished because the AO was asked to examine the opening cash in hand before determining total income of the assessee. This issue had been left by the
dealt by the Sludden ITIT Cuttack against Cuttack, the appellate order, in case the AO had not communicated his finding to the supervisory authority regarding further inquiries made by him. Therefore, the approval of supervisory officer under Section 150 was held to be without application of mine. Then, the Gujarat High Court judgment in case of Salibhadra developers was also been rendered a different fact. The issue pertaining to completion of the order of the AO on 15th 2016, where the assessee firm filed objection before the Honorable State Commissioner on 16th 2016, one day later. The finding of the Gujarat High Court have been made in para 40, 41 of page 10 and 11 of the order. This does not help the assessee case. And this under the Mumbai Tribunal also distinguished it has failed to obtain necessary approval. I'm not going to detail. It also failed to approve. There is no such approval so far as the case law relied upon by the tribunal. And next, the Agra Tribunal relied upon by the assessee. It has been mentioned that CID Central Range Kanpur has mentioned that AO had not discussed the issue with him at any stage of the approval, was sought through a letter sent a speed post without sending assessment record thereby. It was left with no time to ensure that all the observation of the approval report related to investigation issuing pertinent to seized material have been duly taken into account. In the end, he has also mentioned that this case was never discussed with him and there is hardly any time left to meaningful discussion. With this comment, draft order approved by the court under 53D. Therefore, in this context,
at 3:30 or 3:45 minutes, I'm extremely sorry to interrupt. May I come back at 3:30? I'll give my reply today itself.
All right.
I'm grateful. Much sorry.
Therefore, in this context, it was held that Learned Agra ITIT Cuttack, Learned CIT had not applied by granting mechanical approval under 153D. In second, similar fact exists in case of say Rajesh Ladani and DCIT, DCIT tribunals also. Therefore, my lord, I come to the whatever judgment I am now ruling. Before that, your lordship, I am placing lord the page 5, my lord. Without me reading, I'm just placing the 2 line column. I captured this with detailed elaboration, lord. Here, my lord, the 153, the allegation and the order was passed that it's no application of mine so far as the approval has been granted by the superior authority in this case, my lord. Your lordship, see.
You're relying on tribunal judgments.
No. It is not, I'm not relying on it. It is judgment which are relied before the tribunal. I'm placing, basing on which the tribunal has passed the order against the revenue, which has been, yes. Now, my lord, I'm placing a High Court judgment. My lord, the Union of India versus Tata Limited. Next page, my lord.
Page,
internal page 6. I'm attaching, my lord, in page 217 to 229. I mean, the all this gist of the case, I have discussed and reflected in my written note.
All right. It is a cardinal principle.
Yes, that is right. So, therefore, whatever the act stated, we are complied with. There is no ambiguity at all. There is nothing to be, changed while, we have approved the case of the petitioner, Therefore, my lord, this Reliance judgment, my lord, Union of India Tata Limited, the cardinal principle of intermittent statute has to be considered.
Some typographical error in that. It is said that the words themselves best declare the intention of the law and know what chemicals.
Yes, my lord. Yes.
Something wrong.
Chemicals giver.
Chemical gases.
Obviously,
But I'm just.
Where is the judgment?
Start from
great respect, my lord. That judgment is not with the issue 153.
217 to 229. Para 22. Para 22.
Why don't you show us 153
Milord, 153 judgment, Milord, There is no direct judgment so far as these issues concerned. There is no such judgment. Only one case, Gopal S. Pandit was a CIT, but that is a separate issue, Lord. Therefore, Lordship hold it to pass a judgment so far as interpreting the 153D. Yes. Para 22, Your Lordship, 20225, Your Lordship. It is cardinal principle of the interpreting of statute that the word of the statute must be understood in its natural, ordinary, and popular sense and construed according to their grammatical meaning, unless such construction lead to some.
That is already understood.
Yes.
Yes.
I am trying to understand myself.
No, you have understood.
Yes. It is yet to another rule of construction that the word of statute are clear, plain, and unambiguous. Then the court are bound to give effect to the meaning, irrespective of the consequence. It is said that the word themselves best declare the intents of the lawgiver. The court have other principle of the effect should be made to give meaning to each and every word used by the legislature, and it is not the sound principle of construction to basage the word of the statute as being in opposite surpluses if they can have proper application of the circumstances conceivable within the contemplation of the statute. Next, below 20. It is also a settled principle that the court must interpret the provision of the statute upon ascertaining the object of legislation, though the medium or authoritative forms in which it's expressed is well settled that courts should, while interpreting provision statutes, assign its order of meaning. Therefore, my Lord,
what you are reading is based on statute law.
Yes, sir.
And also,
then please come and argue on behalf of the revenue.
No.
Then we are senior counsel, sir.
Yes. But junior to you.
The sum and substance of the revenue stand is reflected in para B of my written note. The approval granted under 153 of the Act by the officer supervisory is merely an administrative order. No civil or penal consequence flow from such an order against the assessee. The approval of the superior official is totally distinct from the assessment or not required to be communicated. Hence, it is not open for the challenge before the court of law. Once the reason of the administrative approval are not required to be communicated to assessee, then it is not permission law to permit the assessee to agitate the reason for passing the administrative approval. The approval granted by the superior officer is not justifiable in law. It is submitted that the subject matter of the proceeding before learned tribunal is the assessment order for which the existence of the approval is necessary. And therefore, the approval cannot, on the basis of challenging the assessment order, to power to determine income based on the exercising the official constitutional function, the act of the administrative approval.
So this is entirely right. Now look at 147, 148.
Yes.
Case law is that merely putting a signature.
Yes.
Not enough.
Yes. That is start from the VAT Act, Lord. Utteswar rights means also there, Lord.
Language statute is not enough.
But that is a reassessment. Here, my Lord, only approval. That is the difference.
Whether it's for the reassessment or for, I'm saying, your proposition is whatever you do on the administrative side is not justice.
Yes.
Correct.
That is also an administrative act. Granting approval for reopening of an assessment.
No, my Lord, that is slightly different what I understand, Lord. So far as reassessment under the OST Act or VAT Act or the Act, my Lord, under the Income Tax Act, my Lord, so far as 140 Lord pointed out, that is the exercising the power of the constitutional authority, my Lord.
No.
Your Lordship, see, my Lord, 147.
It's an administrative approval.
Here, my Lord,
function, sir. Whether or not the assessment should be reopened.
Yes.
That exercise is not a constitutional exercise.
That is administrative.
Just like this.
But there is the notice has been issued. That is a challenge before. What is the notice has been issued? That is the authority who has issued notices form an opinion or not.
You're mistaken, sir. Either you haven't read the provision, you're just answering like this. At least do the courtesy of taking the act and see the provisions. The approval is not granted by the same authority. It is granted by a superior authority.
Correct. 161 is the provisions for the approval. 148 is a substantive provision for reopening.
Lordship is right.
Mechanically answer, sir. If I
Yes,
ask the question, it's after.
I'm sorry, I'm just.
Legal provision.
161. 61.
151.
Sorry, 151.
That is for the issuance of notice
And that's approval.
by the designated authority.
Approval.
Just come to section 151.
Yes, Lordship. Sanction for issue of notice. No notice shall be issued under section 148 of the assessing officer after expiry a period of 4 years from the end of relevant assessment year, unless the principal commissioner or chief commissioner of the principal commissioner or chief commissioner satisfied the reason recorded by the assessing authority that is a fit case for issue of such notice.
This is a sanction.
So this is not a quasi-judicial exercise. Before granting this approval, he does not even have to issue notice to anyone and all that.
Yes.
It's a merely the file will be put before him. He has to apply his mind and grant the sanction.
After expiry of 4 years.
Exact. No. Whoever, depending on how many years, which is a senior officer who has to do it, is determined. But this is not a quasi-judicial exercise. This is a purely administrative exercise.
Yes.
Somebody puts the file before him. He has to read the file and give his sanction.
Yes.
On that, there is enormous case law to say merely saying approved, merely putting a signature is simply not enough.
Yes.
So this whole thing you've developed as you've not seen the case law at all. You're simply glibly saying this cannot be subject matter of judicial review.
But Milord,
have you seen the case law on this one?
This honorable
Sir,
court.
please.
I can share my compilation.
Kindly.
Sorry.
Have you actually seen the case law on 151?
yes, Milord, your Lordship has already rendered a judgment.
Yeah.
No, sir. Have you seen it?
But Milord,
So you're developing a whole proposition without seeing the case law.
But Milord, 150, Milord, my submission, Milord.
In all these cases, invariably the record is called for.
Yes. Here is the
In fact, the High Court sees the record.
Here also record is called for. That has been I am pointing
If it is all that, then how is it not subject to judicial review? You seem to argue in bold letters.
Yes.
That it can't be challenged in a court of law.
Yes.
Sufficient.
Completely contrary to what the law is. Any violation of the machinery section will not render the assessment order void. How do you simply make these statements, sir? Which means you have not seen the case law at all. I don't know. Countless assessment orders have been quashed because the approval is granted in a mechanical way.
Yes.
But here, Milord, the approval which has been granted.
So we're talking of income tax law.
Yes.
This is all case law after case law. The litigants in this area have a lot of litigating capacity. So you have enormous case law.
Yes, Milord, but Milord, so the main, Milord, the submission of the revenue is that, Milord, the approval has been in this case, Milord, after perusal of the order, record and all these things, approval is granted. And it is.
So the grant of approval is the point.
Yes.
I can place, you're a busy commissioner of income tax. 31st December is around the corner. Some 500 orders are kept before you. All they're saying, sir, 31st December is the last date. You're just picking up a whole pile of things and simply signing one after the other. You have not dictated this order. Don't tell me that that officer who signed it dictated it. He obviously did not dictate. Somebody would dictate and he'll simply put a signature there. This is the reality of the situation. That's why the ITAT, when you have those accounts members and all sit, they know exactly what is happening. Even the judicial members know.
But so far, my submission is it cannot be a mechanical manner, Milord. Even Milord.
No, it should not be a mechanical. That's why all this case law.
Yes.
If it is all mechanical, then the statute has no meaning.
No, Milord, if it is Milord 1 day or 2 days, whatever days Milord they are.
No. You can even demonstrate, sir, it was brought to me at 8 a.m. in the morning. I kept reading the file till 8 p.m. in the evening. It was the same day. No problem.
Yes.
Then they can't argue that no, same day is granted, so he's not applied his mind. What you write will reflect what you did. That's why the ITAT is saying there's no, not even 2-3 sentences to say that he has actually read it and understood it.
But the fact remains, my lord, he has perused all the record and
where does he see? This is the whole thing.
That's not properly worded. I understand what your lord.
Who is to imagine all this? Who is to imagine? See, we read the file as we find the file, right?
Yes. But the fact remains, my lord, it is art is not. But so far as I am concerned, my lord, I have to assist your lordship on this issue. So far as the revenue is concerned, my lord, I must say, my lord, the record has been placed. It has been mentioned. Though my lord is not properly worded that A, B, C, D has not been seen or not been reflected in the order or the approval order. But the fact remains, my lord, that all these things, the gist, it has been mentioned 1, 2, 3, 4. Assessment order has been mentioned. Amount, my lord, cannot be assuming. My lord,
no, let's go back to
yes,
what you said. Again, let's go back to these pages. Let's look at the approval. Page 67, right?
Yes.
Read it.
Page 67. Approval under 150D.
This is all subject matter reference.
Yes, not required. Please refer the above. The draft order under 153A, 143D on 41st so submitted by you in the above case. The following assessment is hereby approved.
Where what else is written? There's all simply says approved.
No, Milord, before that, Milord is submitting the records, everything, Milord. It has been.
No. This man is written. That is what that man has written to him. The actual approval is what you just now read.
Yes.
This approval, where does it say that I even see perused?
No, that word is the exact word what your lordship pointed out. That is not there.
It simply says perused full stop. Does not mean that he has applied his mind.
What he has stated or reflected without perusing it cannot be known.
We don't know.
No, that is what
that's the whole point.
Yes, but that is what.
Sir, in fact, then you're denying what the reality is. Have you seen what happens when files are produced before an officer for signature? You're not aware then. Or you're saying, sir, I'm arguing for the revenue. I'm not supposed to say I'm aware.
Either way, lordship.
No, that's right. If you it's like sitting in the corner of that room where the commissioner sits and see what happens on the administrative side. Particularly when these deadlines are approaching, 31st March, 31st December. See, your antenna should go up the minute some approval is granted on 30th March for something that should happen on 31st March.
Correct.
And this won't be the single case. This case somehow traveled to the High Court. Now probably from here it will travel to the Supreme Court. There are thousands of cases which don't travel at all.
Correct.
That day that officer goes crazy. How many cases of backdating? Have you not heard those pleadings?
Yes.
Mr. Rai is specialist in that. Always he gets up and says, sir, it has been backdated. Antedated. But sir, it was actually signed on 10th April. They put the date of 30th March. How many cases you are?
That is the case here, my lord.
See that
I am demonstrating from para 35 of the order. Of the tribunal order, my lords. Let him finish.
See, they've all been, he's been a seasoned lawyer on your side also. So he knows more about the department than you know.
But if your lordship, I pointed out the letter issued to the additional commissioner, there your lordship find there before that page 66.
No. The officer, see, at least the officer putting up the note has to apply his mind. But this will become a worse case if he also does not apply his mind.
No. Fact remain, Milord, the case record, what your lordship falls from lordship, that record all these things has not been properly mentioned, or mentioned that parents.
So somewhere, see, ultimately, why do we make so much about reasons, for instance? We want to know what happens in your mind. I pass a judgment today. I simply say, para 1 of the writ petition says this, para 2 of the counter affidavit says this, writ petition is allowed. First ground and appeal, you'll say, what kind of a judgment is this? We don't even know whether he agrees or disagrees and what he thought of these 2 paragraphs, nothing.
Right.
So the judgment or the order or whatever you write should reflect what is going on in your mind.
But I cannot develop there, Milord. I have to place whatever
I know.
Very good. So, Milord.
Otherwise, post office. See what that earlier man is doing. Please find enclosed.
Maybe, but your lordship, see the before that page 66 part. your letter issued to the additional commissioner.
The key sentence in that whole letter of
Yes.
that assistant commissioner
Yes.
is that the above cases will be barred by limitation of that. This is the key sentence.
That is the.
He's
Because
basically
you
telling
are-
superior officer, listen, don't apply too much mind.
No, that may be other way, Milord. Please complete it as early as possible so that
We don't know how many more files he sent like this that day.
Maybe.
He probably sent some 200 more files.
Yes. Maybe, Milord. That happens.
Seeing these astronomical figures.
But cite one judgment, my lords.
Not yet.
Sorry, yes.
Sorry. It's always great difficulty, sir.
I want to help him.
No.
Let's see page 66, Milord. Enclosed unit kindly find a draft assessment order under 53 of the Act, along with the assessment record in cases of so and so for kind perusal necessary approval of 50D. And Milord mentioned the order, assessment orders, everything, Milord. Therefore, my submission would be, Milord.
No, this is post office kind of letter. Please find enclosed.
No, Milord.
This man has not applied his mind.
So far, so on. I am concerned, Milord. My submission is, Milord, it was submitted along with all the detailed assessment record with this letter, Milord. And my submission would be, Milord, it has been perused and it has been properly examined and quantifying the demands mentioned in the order. Yes, your Lordship is very correct, not properly worded. Or the whatever Lordship, false Lordship not approved is clearly mentioned. But intent is approval. And my submission approval is granted. And Milord, to addition to that, Milord, I have referred in para F of the my written note, page 16 of the factual issues, Milord. Para F. Para F, page 16.
Para F.
Yes. In the instant case, the Lord CIT range on Bhubaneswar being the
additional CIT,
authority to approve the order 150 of the Act was involved in the assessment proceedings since beginning and discussed with carried out on a regular basis for effective and appropriate assessment. It is worthwhile to mention here that each additional CIT endeavor given one set of appraisal report and core document, which itself was elaborate and comprehensive separately by the investigating, and while discussion with the case with the undersigned, the additional CIT used to refer a set of approval report and core document and occasionally called for the seized material which are relevant for passing the assessment order. Most of the incrementing documents were part of the appraisal report and core document itself. Regular discussion were done with the additional CIT before issuing the letter, questionnaires, summons, etc. It was convenient to have discussion and sharing the assessment holder on regular basis with the additional CIT because the close proximity of the office chamber of both of us will share a common wall. To carry out all this internal work, separate folder was created. Hence, it cannot be seen that RCS was thoroughly involved in the whole assessment.
We shared, I don't know, what are you saying?
My saying,
who shared a common wall with the CIT?
Milord, they're sitting, Lord, in the...
No, next to your thing. Right. Who's written this? This is your written submission, right?
Yes. Sorry, Milord. The officers, Milord. The officers share in common wall, Milord. In the very state of...
This is signed by senior standing counsel, Mrs. Tushar Kanti Satpathy.
Yes, Milord.
You share a common wall with the additional CIT.
No. It's meaning thereby, Milord, the officers.
See, this is what is happening.
Yes.
You have also signed. See, look at the classic example. Somebody has drafted, you have signed. We don't need more proof.
That is the approval, my lords.
I must share a funny anecdote. So very often counter affidavits are drafted sometimes in the department and then filed by standing counsel. This happens all the time. So I was working with the additional solicitor general. It was filed in a hurry. So on the left side, they make their comments. So should we, the officer had said, should we really say this to the court? Okay, that was the question mark. And that was filed. You can imagine the embarrassment.
Right. Sometimes happens, Lord.
Many times happen.
Many times. I'm corrected myself many times.
He has given the approval. Mr. Satpathy has given the approval of the written submission.
It's not to be understood like that. Because he has called out the intention of the legislature, not the external aid.
Correct, my lord. Much obliged, my lords. Much obliged.
So, my lord, my submission would be, my lord,
yes,
that approval is granted within the meaning of section 153D.
See, the problem is, on these aspects, nobody leads evidence. Like if this man stood in the box and made a statement, Mr. Ramesh Singh would have thrown him to bits. He would have said, did you really read the sentence? What time did you bring this file? How much time did you have? How many more files were there in a desk? So we don't do that exercise. Which is why in most of these writs, certiorari's, we just go by the record. So that's why court does not even permit you to explain in an affidavit what was happening.
Yes.
They discount because it's very easy to start building stories to what you did. So you can't supply reasons, for instance, if the reasons are not found in the folder. If you've made a noting, you can't now say, no, before I made this noting, all this happened. So this is a problem.
But this is the fact, not this is fact, not
right. That's what. It's a harsh fact. See, we're all snowed down by numbers. All these officers are working under great pressure. There's no question at all. That day, like I told you, you must have had some 300 files.
Maybe.
He didn't know this file will somehow go to the High Court of Orissa to be examined. He just, therefore, hurriedly does everything that he has to do. This is the problem.
Okay.
Yeah, Lord.
This is sum and substance, Lord, and the judgment which are relied upon the natural justice, Lord. I don't want to place it vividly, Lord, but
see, they also have learned from their exercise, which is why this 144B.
Yes.
So much argument is happening. That whole need for draft to be sent is because of this.
No,
because mistakes can happen.
Now new amendment has came into place, Lord.
No, even that has to be correctly followed.
Because you have the indulgence of the various courts.
In other courts, in Court of Appeals and all, I'm sure Mr. Ramesh Singh will be aware. In the Court of Appeals and all, yes, ma'am, they circulate the draft judgment to both counsel.
Yes. In fact,
so that on the facts they can correct it.
Yes.
Because the judge doesn't trust that he would have got all the facts correct.
Lordship is absolutely.
They're not allowed to correct the law portion and other things, but factual portion draft is given to both sides.
In fact, one of my colleagues, Lordship, he's now relocated in London. So in fact, he's shared these experiences.
Correct.
Absolutely.
From the bulky to call out the facts.
Yes,
it is not like suit.
Like ICC.
Yes,
appeared in, all arbitration cases,
yes.
I think senior counsel had appeared.
Yes.
International arbitrations, the draft awards are vetted.
Yes.
Only for the facts.
Facts.
So can I begin?
Yes.
With your kind permission. My lords, I have got the very recent judgment of the Allahabad High Court directly on this point. And there, the approval was given in one day of 100 cases. And here, approval has been given for 49 cases. And the division bench held that it is really not humanly possible. If your lordship will look to Parakates. 122 cases. And here, my lords, I am giving I'm giving a memo, my lords. Here, your lordship will find
at least 49 cases.
49 cases, at least, has been approved on the same day. I'm giving by your memo.
Because of time barring, time.
Yes.
Coming nearer.
Yes. One day was left. My lords, this approval is a sanctity to the orders passed. It was there, even this prior to 153A, when the block period was there, the proviso to section 158 BG, that also said that no order shall be passed without the approval of the Joint Commissioner. And when it was repealed in 2003, this came. So every time the legislature was conscious of the fact that there should not be any arbitrary use of power. So it cannot be said that it cannot be subjected to judicial scrutiny, as my learned friend has given in the written submission matters. It has got a sanctity and it is subjected to the judicial scrutiny. Then, my lords, I'll just draw one paragraph.
So I'm very interested to know this paragraph, which is what you're going to read, I'm sure.
Yes.
It's in case draft assessment orders in 123 cases. Correct?
Yes. 123 cases for 123 assessment years placed before the approving authority on 30th of December 17 and on 31st of December 2017 were approved on 31st of December 2017, which not only included the cases of the respondent assessee, but the cases of other group.
No, my question was,
yes,
reading this paragraph, will all the other 122 people also get the same relief?
Without investing. Matters. And I'll just draw to one paragraph of the tribunal. Thereafter, I'll sit down, my lords. I'll just draw paragraph 35, my lords. 35.
Right, the same what he read.
Further on careful, lordship may get the page 68 of the brief.
Yes.
Lordship will see the bottom portion.
Yes.
Further on careful and vigilant perusal of the assessment order dated 30th of December 2010 for the AY 34 and others related appeals, we are unable to see any mentioning by the AO about the approval of under section 153D of the Act. Our attention has also been drawn to the certified copies of the note/order sheet relating to the assessment year 34 to 910, wherein we are unable to see any noting by the AO regarding issuing of request after seeking approval, seeking approval under section 153 capital D of the Act to the learned SCIT and sending the assessment record along with the draft assessment orders and receipt of approval letter on 30th of December 2010 from the learned SCIT by the AO. So this is nothing, my lords, is a post-dated approval.
Antedated, you mean?
Antedated. It is totally antedated. There has been no approval. Antedated. Antedated. I am much obliged, my lords. That's all, my lords.
Lordship, I'll just take what I've done, Lordship, just assist my lord. I've got made a small compilation. I just in because Lordship seeing the facts, the covering letter,
No, 1 minute. Who's appearing for whom?
Lordship, I'm so sorry. Lordship, I'm appearing in appeal number 45. I'm so sorry, Lordship.
No, it's all right. It's all right.
I'm so sorry.
Mr. Ray is appearing in item number 44 and Mr. S. Ganesh is leading in item number 39.
Acts are all similar, my lord. Only
Right. It's a common order.
Different assessment years.
Yes. Lordship, it's a block assessment.
Right.
There has to be 7.
No, not block. After 153A, each assessment order has to be passed.
No, that's all.
Block period was there prior to 2003.
Correct.
It was amended, repealed the block period, and from June 2003, this was blocked.
Right.
No, Lordship, what I wanted to really place was, Lordship, when the search is done, Lordship, after 153 BG regime is gone, there are 2 sets of orders are passed, if I may use that phrase. For the 6th assessment year, preceding the year in which the search was done, that is under 153A. And the 7th year, the last one, which is the 7-year in is under 153B, B, capital B, small b. So Lordship, I mean that 153 capital B small b the last year of the 7 years, Lordship.
Correct.
Of course, Lordship, the impugn order is common. Lordship, you see, I just wanted to flag one thing from those two letters, and I'll come straight to the law because Lordship is in the
right.
Lordship may come to page 66.
Correct.
My Lord has got. Lordship may see the covering letter of the AO.
Right.
It says 153A. My Lord has got that.
Yes.
Sirajuddin Sonsa under 153A /143.3 oblique 144 145.3. Correct, my Lord?
Correct.
Lordship may also make a note that in the assessment order, the penalty has been passed under 171(1)(c).
Oh,
Lordship may kindly appreciate.
271(1)(c). Sorry.
Yes. Why there is a complete non-application of mind by AO also, which has traveled, being affirmed by the approving authority, is Lordship, in a case like this, if it's a 143(3) case, there is no question of 144 coming in. That's the best judgment assessment. It's either 143 or 144. One. Number two, Lordship, if it's a case like this,
cut and paste.
Lordship, absolutely correct. If it's a case like this where you have 6 plus 7, then the penalty under 171AAA, not 171(1)(c). Lordship. So therefore, there seems to be non-application mind even at the first stage itself. Lordship, it seems to have just traveled along. That's all I wanted to point out from here itself. Lordship is seen one day. Lordship is seen as a matter of fact recorded by the tribunal. No material placed. Yet, yes, the approval, application of mind on the material before the approval is granted. That's a matter of fact which has been recorded. Lordship, may I just share quickly, Lordship. I'll just run through. Lordship has already got that.
But tell me factually, when the ITAT hears these kind of matters,
yes, my Lord,
the ITAT calls for the original files or it does not?
Yes. The files are called. Lordship, in fact,
for the DR to produce the files.
Let me just share one thing, Lordship, because we are having this experience, not only this. Lordship, perhaps in my knowledge, perhaps this would be the first judgment under 153D, perhaps, on approval, Lordship, in my High Court. But the tribunals have started taking the view, Lordship, across the country. I have knowledge of about 5 tribunals cases which have been taken from Delhi, Bombay, Gujarat, Lordship. They have been consistently not taking the view which is placed before my Lord in this case also. The tribunal has started taking these views, Lordship, based on that. So, Lordship, may I just quickly just run through that compilation? Only I'll just, because that's the law, Lordship, I'll just quickly show my Lord the relevant, Lordship, the first serial number 1, Lordship.
The circular.
The circular, Lordship, that's how it was introduced for the first time, Lordship. The circular is introduced for the first time. And if Lordship may just come to page 49. Para 50. That indicates, Lordship, of 50 assessment of such cases, order of assessment or reassessment. The existing provision of making assessment reassessment case where the searches has been conducted on 132 or acquisition is made on 132A does not provide for any approval of such assessment. It was noticed, Lordship, therefore a new section 153D has been inserted to provide that no order of assessment. Lordship, may kindly note, it's in a negative term, no order of assessment or reassessment shall be passed by an assessing officer below the rank of Joint Commission, except with previous approval of the Joint Commission. Such provision has been made applicable to orders of assessment or reassessment passed under clause B of 153A. Lordship, that's the first 6 year. In respect of each assessment year, falling within 6 assessment year immediately preceding assessment year relevant to the previous year in which the search is conducted under 132 or requisition is made under 132A. The provisions also be made applicable to orders of assessment passed under clause B of section 153B in respect of assessment year relevant to the previous year in which search is conducted under 132, a requisition is made under 132A. And Lordship, these are all independent assessment, Lordship. All independent assessments.
Right.
So therefore, you have to apply independently, Lordship, for all assessments order which are needed. Now, Lordship, may come to the next, this manual of procedure. The reason why I'm placing, like, if I already pointed out, Lordship, the earlier it was 158 BG, Lordship. Lordship, may look at the manual of procedure, what the manual of procedure then was provided in 150, almost similar terms. Lordship, may straight away come to chapter 3, which starts at 65. Chapter 3 of which is, Lordship, deals with assessment procedure.
Correct. Search and seizure.
And para 9, my Lord, may straight away have that, my Lord, will get at page 67. That's at the bottom of page 67.
Approval for assessment.
I'm so grateful, Lordship. And assessment under chapter 14B can be passed only with previous approval of range so-and-so for the period so-and-so to so-and-so, the approving authority was so-and-so. The assessing officer should submit the draft assessment order for such approval well in time. The submission of the draft order must be docketed in order sheet and a copy of the draft order and covering letter filed in the relevant miscellaneous records folder. Due opportunity of being heard should be given to Lordship. Now, of course, this is gone now, at least 1 month before. Finally, once such approval is granted, it must be in writing and filed in the relevant folder indicated above after making a due entry in the order sheet. The assessment order can be passed only after receipt of such approval. The fact that such approval has been obtained should also be mentioned in the body of the assessment.
So that's interesting. It must be in writing.
Yes.
They must have anticipated writing by hand, I suppose. I don't know. When was this issued?
Lordship, this is 2003. Lordship, my Lord
still be thinking of
February
writing by hand.
Yes, Lordship, 2003. February
And in
2003.
a written submission, my lords will find that the learned standing counsel, senior standing counsel has said that it is not sacrosanct. It is only, well, this circular has been issued by virtue of power under section 190. Lordship, I'll just...
So it's binding.
It is binding.
Correct. Not us, but definitely the department. Lordship.
Yes.
Lordship, no, I'm so sorry.
No, the next line is very important.
Very important, yes.
Yes.
The fact that
such approval has been obtained should also be mentioned in the body of the assessment order itself, which of course in this case is missing.
That's what
Missing,
I think the ITAT is emphasizing this part.
Yes, it's missing in this case. It's missing in this case. So therefore, Lordship, this approval, this whole internal, if I may use, but it's their own manual, Lordship, and things should not have changed from 153G to 153D. But we look at the whole procedure which is following is completely different. Lordship, 1 month also, it had a logic behind that, Lordship. They also felt that, it can't be done over 1 day. The sufficient time should be given, Lordship. Of course, we are struggling now within 1 day because of the limitations also. Now, Lordship, the next judgment is Sahara judgment. The only Lordship, this was again a case of 142(2)(a), Lordship, with a special audit. There also, as I said, Lordship, there are about 10-15 provisions under the Income Tax Act. At least my learned friend may know more. We see
under the new regime, Lordship will find 148A, which much we have argued.
Correct.
There will, Lordship, the language is now, since with effect from 142021, such assessment is wiped out.
Right.
Now they have made 3 years to 10 years, 149, newly introduced. What they say? You'll conduct an inquiry with the approval of the competent authority. Then B is, he will issue a so cause. Then D is with the approval. So always it is the approval. So approval is a must, is a check and measure on the officers concerned in doing the taxation.
In fact, that's exactly, Lordship. I didn't want to use my word, but that's what the Supreme Court used, and that's what I'm replacing for, my Lord. The next judgment is the Supreme Court judgment of Sahara, my Lord.
Yes.
That was, of course, a case of 142(2)(a). The issue was slightly different, Your Lordship, audio alter partum, whether you have to give hearing or not. But what is interesting, my Lord, when we have para 8, which my Lordship will file a running page 77 of the compilation.
Right.
Lordship, we just have para 8. My Lordship may take it 142(2)(a) also has a provision of prior approval. Para 8. There is no gainsaying that recourse to the said provision cannot be had by the assessing officer merely to shift the responsibility of scrutinizing the accounts of an assessee and pass on the buck to the special auditor. Similarly, the requirement of previous approval of the chief commissioner or the commissioner in terms of the said provision being an inbuilt protection against an arbitrary or unjust exercise of power by the assessing officer cast a very heavy duty on the said high-ranking authority to see to it that the requirement of the previous approval envisaged in the section is not turned into an empty ritual. Needless to emphasize that before granting approval, the chief commissioner or the commissioner, the case may be, must have before him the material on the basis whereof an opinion in his behalf has been formed by the assessing officer. The approval must reflect the application of mind to the facts of the case. Lordship, I think this is what my Lordship has felt more than once. In my respect to submission, it's not being reflected. It should reflect from there itself. In this case, it's not, in my respect to submission. Lordship, I'll take my Lordship to the next judgment. Lordship, the Rajesh Kumar, in fact, that was referred to a Sahara judgment on another point. But Rajesh Kumar, Lordship, the next judgment in para 58, kinds of says almost the same thing. I just wanted to place for the completion purpose. Lordship, the running page at 106. Rajesh Kumar, 2007 2 SCC. My Lord may have running page of the compilation 106 at the bottom, para 58.
Yes.
An order of approval is also not to be mechanically granted. The same should be done having regard to materials on record The explanation given by SSC, if any, would be a relevant factor. The approving authority were required to go through it. You could have arrived at a different opinion. He, in a situation of this nature, could have corrected the assessing officer if he found to have adopted a wrong approach, or posed a wrong question unto himself. He could have asked to complete the process of assessment within a specified time so as to save the revenue from suffering any loss. Same purpose might have been achieved upon production of some material for understanding the books of account and got the entries made therein. Well, exciting is part, the assessing officer has to form an opinion. It is final. So far he is concerned, all this subject to the approval of Chief Commissioner. Again, Lordship, kind of indicates what's the kind of exercise which goes in, the purpose which goes in when you're granting an approval. Lordship, I have next judgment. Lordship, this is under 140. I've put in about 4-5 judgments to Lordship. Delhi High Court has got on 151, Lordship. Just they were said, Lordship, I have page 109. And my Lord may straight away come to para 50. These are 151 cases, my Lord.
Right.
Para 54, my Lord will find at 123. Para 54. Beside this, there is another aspect of the matter which requires to be highlighted. The aspect concerns the grant of approval under section 151 for the issuance of notice under 148 of the Act. As noted in the narration of facts concerning the above captioned petition, the ACIT, while granting approval on so-and-so, made the following identical endorsement. This is a fit case for issue of notice under 148 of the IT Act, so-and-so, full stop, approved. Now, Lordship may come back. Para 50. Given this backdrop, the ACIT, while giving approval under 148 of the Act, ought to have applied his mind to the crucial question as to whether any new or fresh facts has come to the notice of the AO for triggering the provision of section 147, 148 of the Act. The ACIT, on the other hand, mechanically replicated the language of the provision by making the aforesaid endorsement in both the cases. What the ACIT forgot was this endorsement or really his conclusion. And the reason which were to form a link between the material that was placed before him and were required to be appraised by him were missing. So actually, this is another infirmity in this case. The approval thus given by ACIT, in our view, is flawed in law and cannot pass the muster. The observation made by this in safety of trade links, so-and-so, taxman was opposite extracted below. I'm going to read that judgment also, the relevant portion. Lordship, I'll just give the paragraph of that judgment, Lordship, which my Lordship will find at page 145, the compilation.
Yes.
I'll just quickly come, and Lordship may just have para 16 on the facts at 147. Para 16, my Lord, will have 147.
Right.
Para 16, the respondent so-and-so sanction authority has not applied this one. That's a submission, Lordship. Rubber stamp the reason. So correct. And my Lord will straight away come to para 35 onwards. My Lord will find it 152. This apart,
yes.
What is even more disconcerting is the fact that respondent number 2, who accorded sanction for triggering the process under 147, the Act simply rubber stamp the reason furnished for respondent number for issuance of notice under 148. The provision 151 required respondent number 2 to satisfy himself whether it's a fit case for a sanction should be accorded for issuance of notice. So the sanction order passed for respondent number simply contains the endorsement approved. In our view, the sanction order passed for respondent number 2 presents, metaphorically speaking, the inscrutable face of things. See so-and-so. In our view, the satisfaction right of the concerned officer should be discernible from the sanction order passed for 151 of the Act. Should be discernible from there itself. In so-and-so of the Supreme Court in so-and-so, being apposite extracted below. Further, the report submitted by him under 151 does not mention any reason for coming to the conclusion it's a fit case for issuance of a notice in 148. We are also of the opinion that the Commissioner mechanically accorded permission. He did not himself record that he was satisfied that this was a fit case for issuance of a notice under 148. The question 8 in the report was read whether the Commissioner is satisfied it's a fit case. So he just noted the word yes and affixed his signature thereunder. We are of opinion that if only he had read the report carefully, he could have never come to the conclusion of material placed so-and-so. The important safeguard provided in section so-and-so were lightly treated by income tax authority. Both for them appear to have taken the duty imposed for so-and-so important. They have substituted the form of substance. And Lordship, in this case also, as I indicated, Lordship, those infirmity, 144, 271 instead of 271, 11 AAA, Lordship. It was so obvious a mistake, Lordship, in this. So, Lordship, I'll come back. Lordship, the other, Lordship may now come to page 127 of the compilation.
Yes.
And my Lord may straight away come to para 10, which my Lord will find at 129. Para 10. As for the first issue, with respect to approval granted to reopen the system 148, the relevant noting is as follows. Lordship may just skip that. Lordship may just come straight to the bottom of 130, Lordship, after the italics thing. at the left hand side, just above para 11, my lord. ACIT range 30, New Delhi, so and so. CIT approved site.
Yeah, one word.
That's one word. Section 151 of the Act clearly stipulates the CITA, who is a competent authority to authorize the reassessment notice, has to apply his mind and form an opinion. The mere appending of the expression approved says nothing. It is not as if CITA has to record elaborate reasons for agreeing with the noting put up. At the same time, satisfaction has to be recorded of a given case, which can be reflected in the briefest possible manner. This is the lordship. In the present case, it appears to an ordinance, so and so. Lordship, lordship, I don't know. Lordship, the next judgment, para 19. Lordship, I don't want.
No, it's all the same.
It's all the same. The one Maharashtra, Lordship, I can just skip that. Lordship, these are my respectful submission. Lordship, I'm so grateful.
I'll just, before parting, I'll just place one paragraph of the tribunal.
Mr. Ganesh is missing out the whole thing now.
Yes.
Case is over.
3:30.
He wanted 3:30. We can't wait. All of you are paying for the same.
Yes. Para 36, my lords.
All right.
Para 36. Only, Lordship, I'll detain your Lordship for 3 minutes. Not more than that. In the light of above discussion and after considering the attending facts and circumstances, wherein approval of under section 153D of the Act has been granted, it is vivid that the AO by letter dated 29th of December 2010 requested the approving authority learned ACIT to grant approval under section 153D of the Act. In this letter, the AO has mentioned that he is sending relevant assessment records and draft assessment orders for his consideration prior to grant of approval. But this fact has not been found mentioned in the note sheet, order sheet of relevant assessment records regarding correspondences between the AO and the learned ACIT for grant of approval under section 153 capital D of the Act and receipt of approval order dated 30th of December 2010. And in a relevant assessment order, the AO has not mentioned or stated that orders are being passed. Well, the order, even the notice, when it is issued beyond 4 years with the approval, Lordship have come across many judgments. Sub-international Lordship have delivered that judgment in Delhi High Court. That you have to mention is not an empty formality. Lordship in sub-international case have delivered that judgment. So you have to maintain an order sheet. And in the order sheet, you have to note. So that's all, man. It is a case of no approval. It is not a case of mechanical approval. It is a case of antedated approval. It is a case of no approval. Well, with that, my lords, I'm much obliged that your lordship have so patiently heard us.
One judgment I have read upon page 87. Lord. Though it is not directly, my lord, in this case, it is not so far as 271(1)(c) and read with my lord 274(c). Their lordship is
87.
Page 87. My compilation, Lord. Whether failure to obtain the prior approval of the AAC under section 274(2) for imposing penalty under student is a procedural error, not and is not a fatal order penalty passed under 270(1)(c). So you're not directly helping me, but this is a case, not the court held not that it is a procedural irregularity.
All right.
Lords, may I make one request on behalf of Mr. S. Ganesh?
Yes.
My lords, he wanted to address the court for 15 minutes. Could it be on a Friday? He's on his legs, my lords.
No. We're reserving orders today. It's all the same. All of you are appearing for the same person.
My lords,
elaborate arguments have been advanced and written submissions have also been filed. So I don't think we need to. Yeah. And it's not a very complicated case.
Yes. Very well, my lords.
Right.
Very well.
Much obliged.
Orders reserved.
I'm so grateful.
Right.
Grateful.
Weekly list.
Call of the members.
Item 81.
Memo taken on record. No instructions dismissed.
Item 106.
Memo taken on record. Dismisses withdrawn.
Item number 136.
Infractuous dismissed. All right.
Weekly list item number 60.
Madam, 59 yesterday's matter. Today, Mr. Nath is there for the endowment commission. Item 59 may be taken.
Yes.
59.
Now, yesterday's last matter that I was making a distinction that section 25 and 24 of the Hindu Religious Endowments Act. Order under Annexure 6 is challenged. Because it is a Jagir land, section 25 is not available to the commissioner to be exercised. Proper course would have been to before the collector under section 24. And in a previous eviction proceeding also, that is the finding by the assistant commissioner. That
Your Lordship, go to Annexure 1 very clearly say that challenge the Annexure 1, that is the order passed by the to collector, my lord, to commissioner to collector. So 25 against. No, 25 against, Your Lordship, go to 25(3), my lord.
No. He says 25 itself doesn't apply, sir. This is a Jagir land.
Yes, my lord.
If it is Jagir land, 24 applies, not 25.
But the order passed by the...
That's the whole thing. Why he's come here. First of all, you invoke 25 wrongly, and then you say now 25(3) says go to civil court, you say go to civil court.
Yes,
if 25 itself doesn't apply, where's the question of 25(1) or 25(3)?
Yes, my lord. So that my desperate submission that also expired the order. Your Lordship, the voter order, that also expired the order. So that Your Lordship,
whatever. A short point in this petition, which challenges an order dated 4th November 2011, passed by the Commissioner of Endowments under section 25 of the Orissa Hindu Religious Endowments Act 1951 OHRE Act is that the deity is on a land which is a Jagir land, and therefore it is section 24 of the OHRE Act would apply and not section 25. Paragraph. Counsel appearing for the Commissioner of Endowments sought to urge as a preliminary submission that if the petitioner is aggrieved by an order passed by the collector under section 25(2) of the OHRE Act, the remedy under section 25(3) is to go to a civil court. Paragraph. If, as pointed out with the petitioner, section 25 of the OHRE Act does not even apply, then the question of passing orders under section 25(2) or of challenging such order under section 25(3) of the OHRE Act equally will not apply. Paragraph. As pointed out by counsel of the petitioner, section 24 of the OHRE Act is even titled, open quotation, resumption and re-grant of inam granted for the performance of any charity or service, ... unquote. It is this provision that would apply in the event that the land in question is a Jagir land. Full stop. The assertion by the petitioner that the land is of that character, namely that it is a Jagir land, is not even disputed by counsel for the Commissioner for Endowments. Paragraph. In that view of the matter, the impugned order dated 4th November 2011 is hereby set aside. This will not prevent the Commissioner from proceeding in accordance with law hereafter. This will not prevent, the Commissioner or any other person who may be seeking reliefs vis-a-vis the property in question from proceeding in accordance with law hereafter. All right.
Obliged. Item number 60.
Oh, I see. Yeah, no, we can add that. We can add that.
Item number 60.
None appears dismissed.
Item 61.
None appears dismissed.
Item number 62.
I'm even permitted to withdraw this one.
Dismiss this withdraw.
Item number 64.
Item number 64, I am for the opposite party number 1 bank.
Sorry, opposite party?
It is I am for opposite party 1 minutes.
Achha. None appears to the petitioner. Dismissed for non-discussion.
Just my presence may kindly be recorded. Obliged.
Item number 65.
None appears dismissed.
Item number 66.
66, my lords. These matters now, in fact, it covered by the Honorable Supreme Court's judgment in 2020, my lords. Just given a short note. In fact, what happened in these matters is all three matters, Annexure 5 is the impugned annexure. And the tribunal, in fact, relying upon the Gujarat High Court judgment, which has now been reversed by the Supreme Court.
Oh, I see.
And at the same time, we had our own High Court judgment, which should have governed that tribunal's decision.
Right.
That I've just given a short 2-page note for your lordship's reference.
So SARFAESI can't be invoked at all.
Yes, I'm giving the citations also. I've flag marked them. So Supreme Court came to hold that, the 5-judge bench came to hold that the matters, in fact, SARFAESI Act can be invoked by the cooperative banks.
Achha.
So I've given the judgment to your lordship. The first one is the Odisha High Court judgment.
All right. So all this will go back to the DRT now.
Yes, my lords. It had quashed the notices issued under 13.2 and 13.4.
Correct.
So that Annexure 5 has to be set aside and has to be remanded back for.
Correct. In all these petitions by the Urban Cooperative Bank Limited, Cuttack, the challenge is to an order dated. It's a common order, is it?
Yes, I have last page of my note. I've given the different dates of that order. Last page of my note.
No. It's two orders dated
at the bottom.
Yeah. 21st August and 29th September 2014. Passed by the Debt Recovery Tribunal, DRT, Cuttack, in essay numbers 17, 19 and 43 of 2014. Full stop. The said applications had been filed by the present petitioner. No, the said applications had been filed.
Opposite parties are there.
Yeah, by the opposite parties. Questioning the notices issued. And you say under section 17 bracket 1 of the SARFAESI Act 2002.
13.2 and 13.4.
Yeah, questioning the notices under section 13.2 and 13 bracket 4 of the SARFAESI Act issued by the present petitioner bank. Paragraph. The DRT has, by the impugned orders, quashed the said notices by holding that the provisions of the SARFAESI Act do not apply to a cooperative bank, and in doing so has followed the judgment dated 22nd April 2013 of the Gujarat High Court in special civil application numbers 930 of 2011, etc. bracket Shri Dakdi Group Cooperative Cotton Seed versus Union of India. Stop. In that judgment, the Gujarat High Court had declared a notification dated 28 January 2003 issued by the Government of India notifying cooperative banks as single quotes bank in terms of list 1 entry 45 of the 7th schedule as ultra-virus, and held that cooperative banks cannot invoke the provisions of the SARFAESI Act. Paragraph. The above judgment of the Gujarat High Court has been now reversed by the judgment of the Constitution Bench of the Supreme Court of India in Pandurang Ganapati Chowgule versus Vishwas Rao Patil Murugud Sahakari Bank Limited, 2020, 9 SEC 215. Full stop. The Supreme Court has held that cooperative banks can invoke the provisions of the SARFAESI Act.
Para 142.
Paragraph. In that view of the matter, the impugned orders of the DRT are hereby set aside, and the aforementioned three essay numbers 17, 19, and 43 of 2014 are restored to the file of the DRT, where they will be listed for hearing on 3rd April 2023. We'll stop. A copy of this order be sent to the presiding officer of the DRT Cuttack forthwith.
Obliged, my lords. All three matters.
Yes.
Item 67.
Item 67, no instruction.
No instructions dismissed.
Item number 68.
None appears dismissed.
Item number 69.
I'm for the bank in this matter, man. Opposite party bank, man.
None appears to the petitioner dismissed.
My name may be different. Obliged.
Item number 70.
None appears dismissed.
Item 71.
None appears dismissed.
Item number 72.
Well, the account is closed through compromise and it is.
All right. Counsel, the petitioner, respondent bank states that the account has been closed. The petition has been rendered infructuous and is disposed of as such.
Petition. Well, he is for the petitioner.
All right. Counsel, the petitioner is. All right.
My presence.
All right.
Item 73.
None appears dismissed.
Item number 74.
My lord, item number 74, the arguing counsel, Mr. Viday Patna, is expired in the meantime. Kindly, my lord, keep it till when we get. I've asked the instruction if he'll power will be given to us. Sir.
On board. All right.
It is item 75.
My lord, item 75, the repetition is infructuous, my lord.
Okay. Infructuous disposed of.
Item number 76.
None appears dismissed.
Item number 77.
None appears dismissed.
Weekly list item number 78.
I am for the opposite party back, madam.
None appears. The petitioner dismissed.
My presence will be noted, madam.
Item number 79.
And here I am for the opposite bank. This
All right.
matter has
None
been
appears.
decreed and
None appears for the petitioner dismissed.
my name may be reflected.
Weekly list item 80.
None appears dismissed.
Weekly list item number 82.
None appears dismissed.
83.
Same.
84.
Same. I think 84 to 86.
84 85 and 86.
All dismissed for non-discussion.
Weekly list item number 87.
May it please, my lord. The petitioner is challenging the suo motu revision excess power exercised by the collector in cancelling the lease under OGLS Act, my lord.
When did you buy it? You are a third party purchaser or original lessee?
I'm the third party purchaser. I purchased from the lessee.
When?
I purchased it in the year 1984.
Okay. You say on the short ground that the impugned order dated 19/12/2014 of the Additional District Magistrate Bhubaneswar in RC number 9 of 2014 was passed without notice to the present petitioner, who had purchased the land in question
My lord,
from the original lessee.
we are noticed, my lord. We are noticed. The grounds which we have taken is rather a very legal ground. One is that there is the Limitation Act. There is a limitation of so for exercising the power of revision, it is only 12 years. Now they have 14 years. I'm sorry. Now they have exercised after 40 years. That's one ground. The second ground is that the suo motu power revision under section 7A3 cannot be exercised in this case because there are three separate grounds for exercising the suo motu power. There is on the ground of fraud, misrepresentation, and irregularity in the proceeding. Here in this case, they have taken this. The collector has taken this ground that we have utilized for the purpose other than which it was granted. Now that particular the violation of the lease or the lease clause that can be exercised by the Tahsildar under section 3, not under section 7. That Tahsildar can have power. So these two grounds are that in both the cases the collector has no competency to exercise the power. And in the meantime, my lord, what has happened? This law has in the meantime changed. Now what the state government has done, after the power was exercised in the year 2014. In the 2014, the limitation power, that particular clause has been removed from the OGLS Act, and in the year 2013. Now, virtue of that removal of the power that exercised as 12 years, the 14 years was there is no more. Now, taking advantage of that amendment, that this power has been exercised. My contention is that amendment which came in the year 2013 is prospective in nature, and the right which have already accrued after the lapse of 14 years in the earlier provision, that will accrue in my favor, and this will be not retrospective. By virtue of this amendment, they will take in the one stroke, they're trying to cancel all the leases which have already been accrued. These are two grounds we have taken, my lord.
Yes. Yes,
My
Mr.
lord,
Malik.
where this petitioner was noticed, I don't find Navin Chandra.
Yes, he has also given an objection at Annexure 6, page 17.
As per the RI report, my lords, this is the same type of case where he has misrepresented his caste and lease was obtained by his vendor by misrepresentation of caste. And he has not.
That's not the ground on which he says it's been cancelled. He says the only ground on which it's been cancelled is that you didn't utilize the land.
Yes, my lord. And that it is in jungle land, it's not suitable for this agricultural purpose for which the lease was granted. Jungle land, at that particular point of time, many jungle lands were leased out by the then
No, but then how do you invoke the power after 30 years first? Only for not utilizing the land for the purpose for which it was granted.
Your notice is otherwise. The lessee has not used the leased out land for the purpose for which
then that is a ground when Tahsildar can invoke 3B. What my learned friend is saying, that is correct. This is a good ground to invoke 3B.
Correct. You say the challenge, the challenge in the present petition is to an order dated 19/12/2014 passed by the ADM Bhubaneswar in RC number 9 of 2014. Cancelling the lease of the land in favor of the original lessee in the land at Khata number 574/09, plot number 1505/2394 in Moza, Gangapatna, to an extent of AC 1.000 decimal. Bracket, hereafter the land in question, bracket. Paragraph. It appears that the impugned order was passed under section 7 capital A bracket 3 of the OGLS Act 1962. We'll stop the notice dated 3/12/2014 issued to the petitioner alleges that, open quotation, the lessee has not used the leased out land for the purpose for which it was granted. Unquote.
Your lordship may observe that hardly this can be a ground to invoke section 3B of the OGLS Act. That observation may be referred.
As rightly pointed out, the conditions for invoking section 7 capital A bracket 3 of the OGLS Act, and that too within a period of 14 years from the date of grant of the original lease.
7A subclass 3.
Yes. Is that the original order should be passed, open quotation, under a mistake of fact, semicolon, or 2, owing to a fraud or misrepresentation, semicolon, or 3, on account of any material irregularity of procedure. Paragraph. None of the above 3 grounds are attracted in the impugned case, in the present case, and therefore the ADM could not have passed the consequential order cancelling the original lease. Full stop. Paragraph. It is section 3 capital G of the OGLS Act that can come out. No, 3B.
Capital B.
3, yeah. That
3B.
can at all be invoked in the event that the person in whose favor the land was settled, open quotation, has used it for any purpose other than that for which it was settled, unquote. For the aforementioned reasons, the impugned order of the ADM is hereby set aside. This will not prevent the government authorities from proceeding in accordance with the provisions of the OGLS Act hereafter.
Section 3B of
okay, Section 3 capital B of the OGLS Act. The writ petitions allowed in the above terms, no costs.
The other from
other cases, only plot number, khata number
Yes.
will be changed.
That is up to 91, all are similar. Only lease cases are changing and lessees are changing.
All right.
Quick list item number 92.
May I please, Your Lordship? In pursuance to my law, auction sale of a vehicle, my lord. Auction sale of a vehicle, the petitioner participated, my lord. He deposited 10,000 rupees on the Annex 2, my lord. The total bid amount was more like 40,000. That is reflected at Annex 3, my lord. But in fact, the tractor was not there, my lord. The trolley was also not there, my lord, to which the petitioner participated. There was another tractor, my lord. However, he deposited the 25% of the amount, my lord, as has been fixed on the Annex 2. Thereafter, he submitted a representation to the authorities concerned on the Annex 5, my lord, that the tractor itself is not available in the parking area. It is difficult for me to deposit rest amount, my lord. That representation is at Annex 5, my lord. Thereafter, the tractor which was there in the parking area, my lord, that person also submitted a representation on the very next day, on 27th. On 26th, the petitioner submitted the representation. On the very next day, the owner of that vehicle submitted a representation. Neither they are paying the deposited amount, nor they are delivering the tractor, my lord. For which,
now, no point tractor, sir. 2013.
My lord, they have taken 35,000 from the petitioner, my lord.
Sorry?
35,000 they have taken from the
So they
petitioner.
should return that 35,000 to you.
That has been forfeited. Yes, my lord. They should return back
As
that
per
amount.
Annex of 1, if he doesn't deposit it in time, it will be forfeited. A clear-cut terms are there. Auction, he was a successful bidder in one lot in annex serial number 6 of the vehicle. He deposited 25,000, but the rest amount he didn't deposit within time. So that has been forfeited. And thereafter, again, another auction was held and
been sold.
Sold.
But the tractor and the trolley itself was not in the parking area, my lord. They have also not filing the counter, my lord, in spite of the.
So how you can't get back the tractor now? You only get back, how much did you deposit?
25,000.
25,000.
What does it?
Age entitled, my lord, 25.
So admittedly, the remaining installments were not deposited in time.
No.
In view of the fact that the tractor was not there, my lord. That is the reason, my lord.
Who's going to?
That is the reason that reflected Annex 5, my lord.
That's only a representation, sir. Concept of the petitioner states that since the tractor itself was not available with the respondent opposite party bank, the petitioner did not deposit the balance amount, successful bid amount. Stop. The grievance is that the respondent bank has neither delivered the tractor nor refunded the initial sum of rupees 25,000 deposited by the petitioner. Paragraph concept of the bank, on the other hand, points out that the petitioner defaulted in paying the installments in terms of the conditions attached to the auction, as a result of which the initial amount deposited, that is rupees 25,000, was forfeited. Full stop. He further adds that a fresh auction was held and the tractor in question has been already delivered to the successful bidder. Full stop. Paragraph with the petitioner being unable to show that he had paid all the installments in time. And with there being no material to show whether, as claimed by the petitioner, the tractor was not available at the relevant time, the court is not inclined to grant the relief as prayed for. The writ petition is dismissed.
Item number 93.
None appears dismissed.
Item number 94.
None appears dismissed.
Item number 95.
None appears dismissed.
Item number 96.
None appears dismissed.
Item number 97.
None appears dismissed.
Weekly list item number 98.
98, I am appearing for the bank, Lord.
All right, none appears for the petitioner, dismissed.
Item number 99.
99, my lord, I am appeared for the Bhubaneswar Municipal Corporation. My lord, I am for the petitioner, your lordship. My counter is ready, but due to your lordship grant me 7 days time only. Next week only.
What's the matter about, sir?
Yes, sir. This is regarding rehabilitation of the vendors, your lordship. In the year 1998, GA department allotted the land for the rehabilitation of the vendors, your lordship. But no step was taken. Thereafter, the petitioners approached this honorable court. And while the matter was pending before this honorable court, another order was passed by virtue of which, my lords, the municipal corporation requested, your lordship, can glance to page 25, Annex 2. Page 25, Annex 2. This is a letter, my lords, from the GA department to the executive officer, Bhubaneswar Municipal Corporation, regarding allotment of the land for rehabilitation of the petitioners, my lords. But that was not carried out, your lordship. The petitioner approached this honorable court in the.
So you've continued for the under the stay order, you're continuing.
Millers.
And my instruction is we have not made any loudspeaker announcement to demolish their business or because my instruction is, my lord, in this way. Only to create a cause of action, they have taken such a statement that we are in a loudspeaker announcement.
This is regarding rehabilitation. Land has already been allotted by the GA department for this purpose.
No, that is, I am denying. In my instruction is not a fact. Therefore, I pray only 7 days time.
Let it stay on board, otherwise you file the count in the meanwhile.
Yes,
give him a copy.
Yes,
right.
Item 101.
None appears dismissed.
Item 102.
None appears dismissed.
Item 103.
For the opposite party.
None appears to the petition dismissed.
Item 104.
I'm for the OP. I'm for the OP.
None appears to the petitioner dismissed. No discussion.
Item 105.
None appears dismissed.
Item 107.
107.
107.
I'm for the opposite party, Lord. I'm sorry.
Hello, this is a challenge to the award dated 21/2014 of the Industrial Tribunal. This disciplinary proceeding of the brief facts are a disciplinary proceeding was initiated for impersonation against the workman. He was dismissed from service after the disciplinary proceeding was concluded on 23/11/2004. He preferred an appeal that was also dismissed. And then the matter is the Industrial Tribunal. The Industrial Tribunal framed 4 issues. That's on page 30 of the of the brief. The 4 issues, my lords, were whether the reference is maintainable,
whether the departmental inquiry started against the workman Sri Gajendra Kumar was conducted fairly with due regard to principles of natural justice, whether dismissal of the workman Sri Gajendra Kumar, the effect from 8/12/2004 is legal and justified, if not, to what relief the workman is entitled. But it was incumbent upon the industrial tribunal to have at least come to a finding whether he was guilty of impersonation. That finding has not been made. That discussion is at page 32, my lords will find, because he has framed two separate issues. One on the violations of principle of natural justice, and the second whether the punishment was justified. So he should have come to a categorical finding on the second issue, on the third issue, and then principles of natural justice. My lord will find that the discussion on that is on page 32 in negative terms. May I place, my lords?
Yes, please.
Second line. It was also revealed that Sri Chandramani Swai has two sons, namely Sri Narsingha Charan Swai and Sri Uddhav Charan Swai, and some sale deeds have been executed in the name of Sri Uddhav Charan Swai, son of Chandramani Swai. But there is no iota of evidence that Sri Uddhav Charan Swai is not known by the other name of Gajendra Kumar. Negative terms. And then page 35.
Who's for the workman?
I'm appearing for the workman, my lord.
Okay.
Your lordship,
I'll just complete.
Okay.
No, 17B has been complied with.
Yes.
17B has been complied, and he has been superannuated.
I'm coming to that. So, my lords, page 35, the finding is, therefore, there is no iota of doubt the domestic inquiry is not going to fill in properly. It was left incomplete, and no opportunity to adduce defense evidence was given to the charge sheeted employee. So, my lord, the law on this point, my lord, is 2008-12 Supreme Court cases 30. I'll just give you. The categorical observation of the learned apex code is in cases where there is violation of principles of natural justice and the inquiry is not complete, then either the tribunal should come to a finding or the tribunal should send it back to complete the inquiry and then proceed accordingly.
He's already retired, sir. No point.
He's retired only now in April.
No, but he's retired.
22.
Why would drag him now to an inquiry and all that? Not necessary.
Then, my lord, the reinstatement with full back wages, my lord, my contention is not justified. He's already 17 has been complied. He's drawing his last pages without doing any work since 2015.
This will get adjusted when you pay for the
yes.
All that you paid in 17B will get adjusted when you pay the arrears.
So, my lord, arrears, full back wages, my lords may not grant. That's the only submission I'm making right now. Because it is not worked for the entire period.
He was not allowed to work.
And how many years, sir, was that?
8 years. From 2015 to 2022 June.
So we can say 50%, sir?
I cannot say anything, Your Lordship.
All right. The challenge with the management in this petition is to an award dated 20th January 2014 passed by the Labour Code, Industrial Tribunal cum Labour Code Bhubaneswar, bracket Tribunal, in a dispute case number 36 of 2007. Paragraph. The following dispute was referred to the tribunal to the tribunal, then take from page 23 top. Paragraph. After completion of pleadings, the tribunal framed the following issues for consideration. Take from page 34 issues. Paragraph. While issue number 1 was answered in favor of the management, on issue number 2, the tribunal concluded that, open quotation, there is no iota of doubt that the domestic inquiry was not conducted fairly and properly. Full stop. It was left incomplete and no opportunity to adduce defense evidence was given to the charge sheeted employee, thus conducting the grossly violating the principles of natural justice. Full stop, unquote.
Also, before the tribunal, they were given a chance and they could not. Your Lordship, may kindly see the issue number 4, just above line. They were also given the chance.
As
The
far as-
evidence.
Sir, I've noted that this was decided against the management.
Yes.
As far as issue number 4 is concerned, the relief granted was reinstatement, full back wages, and continuity of service. Paragraph. While directing notice to issue in the present petition on
That is on
1-7 on 28th August 2015, the impugned award was stayed, full stop, by a subsequent order dated 10/12/2015. It was directed that payment under Section 17, Capital B of the Industries Act 1947 would be made to the workman during the pendency of the petition. Full stop. Paragraph. Counsel, the workman confirms that the above order has been complied with. Full stop. Nevertheless, he points out that the respondent workman has since superannuated. Paragraph. That view of the matter, it is plain that the workman cannot be granted the relief of reinstatement in service. Full stop. On merits, the court finds that clear and cogent reasons have been given by the tribunal for coming to the conclusion about the lack of fairness in the domestic inquiry. Paragraph. Mr. Nayak, learned counsel appearing for the management, then urges that the tribunal was not justified in ordering full back wages, particularly since the petitioner had not worked for nearly 7 years. Paragraph. Having heard learned counsel the parties, the court is of the view that the impugned award of the tribunal requires to be modified only to the extent of the ordering of full back wages. Stop. It is directed that the management will pay the respondent workman 50% of the back wages. Full stop. The said payment now be made within 8 weeks, failing which the amount will be paid together. The said amount will be paid together with simple interest at 6% per annum till the date of payment. Full stop. The writ petition is disposed of in the above text.
May I suggest, my lord, online the amounts already paid will be adjusted.
That cannot be 50%. They have got already, my lord.
Yes. All right.
Item number 108.
May I please not. I have filed a sufficient petition, Lord. The proprietor in the meantime has spared. And this case is covered by Lordship's judgment. Lordship, see the order sheet I have given. It is one is Endure and next one is Kesab Automobile. If you Lordship see the order sheet.
Who's for the department?
My lord, I'm there, my lord. With BC, my lord. It's covered by my lord Kesab Automobile.
Or Kesab Automobile and both, my lord. And the RK Industries.
In view of the judgment of this court in Keshav Automobiles, confirmed by the Supreme Court in Rathi Steels, the impugned assessment order and the consequential demand are hereby quashed. The petition is disposed of.
Here it is, my lord, the audit report, your lordship held the judgment. So far, Endure. That also covered. My lord, the order sheet I have given is also.
All right.
I is not recorded. Once it is. Lord, substitution may be allowed, my lord. I have filed IA substitution petition may be allowed.
That to be numbered, IA taken on record, substitution allowed. All right.
Much appreciated.
Item 109.
None appears dismissed.
Item 110.
None appears dismissed.
Item 111.
111, I'm for the OP number 2, your lordship.
All right. None appears, so the petition is dismissed.
Item 112.
None appears, so the petition is dismissed.
Item 113.
Same order.
Item 114.
Similar matter has been listed before court number 1 before Justice Honorable S. Talpatra. Similar matter has been listed WPC number 12,586 of 15, 12,587 of 15, 12,588 of 15. These matters have been listed before this Honorable Court number 1. Honorable Just.
When is it coming up?
My Lord.
When is it coming up?
Today it is, but unfortunately the court has not been functioned. Today it has been listed for today, but unfortunately court has not functioned today.
What is the date given, sir?
Earlier it was fixed for today, but on
Today the case was listed, so.
All right, list along with those 3 writ petitions before the same bench, where the other 3 writ petitions are pending. All right.
Obliged.
Item 115.
None of this dismissed.
Item 116.
None of this dismissed.
Item 117.
None of this dismissed.
Item 118.
None of this dismissed.
Item 119.
The 119 is the demand notice and audit objection, Lord. Covered matter, Lord. I'm handing over the order.
Audit objection.
Yes. Annexure 7 is the demand notice and audit objection.
All right.
Obliged.
Item 120.
In this case, I am appearing on behalf of the opposite party number 3.
All right. None appears to the petitioner. Dismissal not discussion.
Item 121.
And I am appearing for the corporation.
All right. None appears to the petitioner. Dismissal not discussion. The contempt case is also dismissed. Right.
Item 122. Item 122.
None appears dismissed.
Item 123.
None appears dismissed.
Item 124.
May I please, my lord? This is an unfortunate case before my lord. In 1993, lease was executed and deposit the premium amount with the direction to deposit the development cost. I also deposited that immediately in 2004, 94, 1996. And in spite of that, the government is not giving me the allotted land till today. Now, Annexure 6, 2006, my lord, government asked Annexure 4 to deposit the things. Already received the payments into 93, 94, 95. Then, the government has not filed a count in this case till today. Why they have slept over the matter till now? And 93 matter, lease did executed, money paid, development cost paid, 38,000 allowed. Till then, they're sleeping.
Let's stay on board. I'll take instruction.
All right. Stay on board.
How many years? Let them pay some compensation, sir. Let them notice.
All right. Stay on board. All right.
Staying on board, sir. Staying on board.
He wants to find out. He wants time for instructions.
Item 125.
None of this.
25 pass over your.
On whose behalf? On whose behalf?
On behalf of Mr. S.K. Samantrai, Sanjay Kumar Samantrai.
All right. Stay on board. All right.
Item 126.
126 minutes. Lord, here we are challenging the virus of the Section 22A of Registration Act. Lord, I have supplied some citations in this regard, my lord. The state has not filed any counter, my lord. If they can file the counter, my lord, this matter can be heard. Lord, we have Lord, the Section 22A and the circular also we have, my lord, challenged, wherein it has restrained the sub-register from, my lord, registering a document where if there is no ROR, my lord, they say that they cannot register the document. On that regard, my lord, we are challenging the virus of the Section 22A, my lord.
They have filed a suit for partition, sir.
My lord, that part is there, my lord. There was some requirement when she filed the petition, my lord, there, the document there, the authority refused. on the
And
point
the-
that she has
The
no
instruction
ROI.
of that amendment, the objective behind it that the people are making all forged cell deeds without any record of right. So there is a circular of the government that you have to produce the record of right. Prima facie showing that you have a right title interest over the property in question, which is sought to be transferred.
Still, it is curtail the right of the Milord intended seller, Milord.
How
And there
can
is
it curtail the right if you are the rightful owner?
is
You
against
give the
the
record of right and register the document.
Section 44 and 46 of Registration Act also. It is against that, Milord. Lord, let them file the counter, Milord, so that this matter can be ordered.
Why should it be taken up like this in the writ petition?
Milord? Milord, my prayer is that, Milord, I am challenging the virus, Milord.
That's simply to attract the writ jurisdiction somehow.
Milord, my case is relating to this point only, Milord.
No, there is no interim order granted here.
No interim order.
No, the practice is going on since long. This, you have to produce the record of right and then registration will be allowed. This practice is going on since long.
Correct.
Lord, let it come next week, Milord.
Now
We'll
it is
argue
unusual
then.
on the part of the petitioner to say that I have no record of right. I may be allowed to register the document.
Lord, then give me
Which will
some time.
create a
I'll
chaos.
argue this case, Milord, next week, Milord. Okay.
All right.
Next week, Milord.
127.
My lord. One good thing I add to my lord. So counter copy has not been sought.
It's all right. What is the matter? What tell us?
So it is a matter of arising out of 15B of OC for the settlement act. The commissioner illegally rejected my disputed land. Thereafter, this writ application before the owner. So counter copy is directed to.
What is your case, sir? Why don't you make out your case? Counter will come later.
So this is a case. In this case, my lord, the Jamamandi and the possession and tenancy letter strictly stood in favor of the petitioner since long. So, although I am regularly paying the Jamamandi and the tenancy letter stood in my favor, but the illegally recorded in the name of the government. Thereafter, I filed the revision case before the CLRS court. The CLRS court outrightly rejected my application. Thereafter, this writ application before honor.
The government land, the learned court below has discussed the materials on record and came to the last para 8.0 may kindly be seen at page 47 of the writ petition. Above all, the civic status of the suit land was Anabadi. As per the report of the Tahsildar Bari, who is the custodian of the records, in his memo number so and so, and the assistant settlement record room Cuttack. The purchase, if any, from the very inception, during the Sabik settlement, this land was recorded in Anabadi Khata, that is the government land. And he is showing that some paper like tenant ledger and Ekpadia or something like that. But the court has held that all the records right from the Sabik position stands in the name of the state government. The purchaser, if any, made by the interveners by government land is non-est in the eye of law. It is a settled principle of law that settlement authorities are not competent to record a government land in favor of a private person. On the above grounds, it is ordered that to record the suit land in favor of the government. So it is a government land right from the Sabik status. The only and in the previous page 46 at para 6.0, he has also taken care of the position of law. At para 60, entries in Jamamandi are not proof of title as decided by the Honorable Supreme Court. Hattapatta is inadmissible in evidence as per the decision reported in so and so. Something. Your Lordship has also dismissed many cases which are based on Hattapattas. These are all forged and manufactured Hattapattas. There is no registration, nothing. And collection of rent is an administrative act and it does not operate as recognition of pre-existing right and interest as decided by the Honorable Supreme. He has cited 3 Supreme Court's decisions, basing on which he came to a conclusion that the documents basing on which he is claiming his ownership, that those are not the title evidence of title.
Book? You don't have your paper book also.
Oh, I mean, my lord, I pray before Lordship. So counter copy may kindly be sought. So matter may come next to me.
Where is your paper book? Where is your paper book?
So that is I'm not the conducting advocate.
Then why are you bothered, sir?
Sorry.
Can't walk into a high court like this without papers and simply ask for time. That doesn't work here.
So only one.
No question. No question at all. Where is the lawyer who's conducting the case? Who's conducting the case?
So Mr. B Das,
Where is he?
so he interested me.
Interested you just to go and walk into the court.
So my file is available to him. So
He simply keeps the file and says, you go and take time. What is this?
So kindly, 1 week time.
For what? 1 week time without your having even papers.
So matter.
You are not the authorized counsel to appear in the matter also.
Tomorrow matter may come. Tomorrow matter may come.
All right.
My lord.
To stay on board. So don't treat the court so casually. Yes.
Item 128.
Never walk into a court without papers, sir. You're a lawyer. Somebody asks you to go into the court and say something to the bench, you simply walk in and say without papers.
Wait, I don't know.
128.
None appears dismissed.
Item number 129.
May it please. Under Annexure 1, there was a direction by the Commissioner of Endowments to conduct inventory of the institution.
So this has not even come once in last 8 years. Never listed even once. Amazing. What has happened in the last 8 years? Are you aware?
On 18/1/2016, it came before this Honorable Court, and I have removed all the defects and other things, and it was in the weekly list on 20th February to 22nd.
At least our record shows this court has never passed any order in this.
Right. In the weekly list, it is coming and not reaching Melon. That's right.
No, how can it go to weekly, sir? It has to come for admission, no?
That's right, man.
How did it disappear like this? Sometimes I have practiced in the bar, but the practices here stump me. I don't know if this is also part of tradition where I should not question it.
I quite understand that. And each time...
Everything is tradition. Everything is hallowed. So if a matter doesn't come up for 8 years, nobody should ask any question.
No, we are also disturbed for that. But the reason is...
Meaning what? If I was in your position, some client matter I filed, it has disappeared. I don't even do anything. I have never, that is not what I have been... Anyway, tell us what has happened in the last 8 years. At least that you should tell us.
The scientific way when how the things are going on, that was not there in the past.
I know, sir, but still tell us what past 8 years, what has happened?
The controversy is very limited, my lord. There is an institution. It is the Commissioner of Endowment has directed inventory has to be conducted in respect of the institution. And that was not done. Therefore, I have made a representation and I came representation.
You want to make a fresh representation? Do that, sir. We'll permit you to do that.
I think that will solve the
counsel the petitioner seeks leave to withdraw the present petition with liberty to make a fresh representation to the authorities in accordance with law and after following up on such representation to seek appropriate remedies. All right.
Let me say that Commissioner of Endowment with
appropriate authority, I've said. So you make it, no problem.
Right. 130.
Let me fix up some time limit, my lord, because as it is, it's late.
It's all right, sir. It's all right. Right.
130.
None appears dismissed.
Item 131.
None appears dismissed.
Item number 132.
None appears dismissed.
Item number 133. Item 133.
None appears dismissed.
Item number 134.
No instruction, madam. No instructions dismissed.
Item number 135.
No instructions. No instructions dismissed.
Item number 137.
None appears dismissed.
Item 138.
My lord, 138, my lord. Next day, my lord, I filed a legal certificate, my lord. My lord, till that, counter copy not filed, my lord.
Counter will not automatically be filed, sir. Anyway, who has died? Petitioner has died.
Yes, my lord.
Substitution application is there.
Yes,
Legal error certificate not filed. Oh,
well, next day,
all right, stay on board.
Item 139.
oh, please. My lord, till that interim order continue, my lord.
You're not passing any order.
Stay order.
Oh, please.
139.
It is a peculiar case, my lord. What has happened? There was a scheme of the government and the Khadi and Development Department, Khadi and Village Industries Department. Under the scheme, brick kilns are to be constructed. So I have availed loan from the bank, this opposite part number 3, and constructed the brick kiln. There was a heavy rain and all the brick kilns were destroyed, particular year. Thereafter, I made a representation, so also several others, to waive the interest part of it. Because in the meantime, the government has not sanctioned any.
What is the amount outstanding?
Amount outstanding, according to them, is nearly 9 lakhs and odd.
My lord, opposite party number 3 is a cooperative central bank, my lord. Governed under the Odisha Cooperative Society Act. We have passed a reasoned order or annexure 9, page 52. That order may be challenged before the registered cooperative society under section 68 of OCS Act.
Unreasoned. You will also
remedy available.
Page 52. Have a look at one line order. Let him pass a reasoned order.
We have passed, there is no provision.
There is
the interest. My lord, we are borrowing money from the Odisha Cooperative Society, Cooperative Bank, giving interest.
What is the total amount due, sir?
95 lakhs.
What is the amount due from him to you? You might as well get some money instead of postponing it. Find out what is the amount due.
Yes.
Then settle the matter. If you can waive half the interest, when 80% of the interest, have a reasonable percentage, you might as well get some money for your bank.
Yes,
there's a complete
your lordship may pass order, reasoned order. We shall settle. We shall settle.
First of all, what is the amount due?
95 lakhs.
95 lakhs?
9 lakhs.
9 lakhs.
You don't even.
Sorry. 9 lakhs. I take instruction.
Stay on board. First of all, find out, sir, please. And what is the value of your property? That
I'll find
out. All right. Stay on board.
In that 2015, 6 lakhs is due. On that interest must have been found.
Correct. Correct.
Representation of the.
Correct.
Item 140.
None appears.
Item 141.
None appears.
141, my lord, or 1 pass over, my lord. Mr. Misli is arguing vote number 70, my lord. So
all
1
right.
pass over, my lord.
All right, stay on board.
Item 142.
None appears.
Item 143.
May I please your lordship, my lord. Here, my lord, I am challenging the order dated 24/11/2010 passed by the Tahsildar Chandali in Khasmal case number 73 of 10. My lord, by the annexure 4.
This Tahsildar's order must be an appealable order.
No, my lord, there is no appeal, my lord.
Meaning, what is that order?
My lord, that is a the petitioner filed an application under the Khasmal lease principle. Khasmal lease principle, my lord. The Tahsildar rejected my application in a very cryptic manner, my lord.
No, rejected which application for what?
My lord, this is a Khasmal land, my lord.
Not covered by OGLS Act.
It is a
lease. He applied for lease. Tahsildar has rejected. He can approach the sub collector against that order.
No, my lord, there is no provision for appeal, my lord. If your lordships kindly permitted me the notification of the government, my lord, on which
this is government land, no, sir?
My lord, this is a government land, my lord.
You want lease of government land?
No, my lord, there is no appeal because there is under the government notification, the petitioner filed an application under that the notification, my lord. If your lordships kindly see the order dated passed by the Tahsildar, my lord, rejected my Khasmal land on the basis of notification number 5374 dated 11/2/2010, my lord. That is a government notification, and according to that notification, there is no appeal provision, my lord. Only read is maintainable, my lord. If your lordships permitted
Then
me,
actually he has no case. Your
No,
lordship
no.
may see the impugned order.
my lord, if your
As
lordships,
for the joint inquiry report of the applicant and her family are not are in possession of the case land since so and so for
Right.
homestead business purpose. By registered deed conveyance number so and so. Hence, as per government notification, this notification itself provides that they are not entitled to get the lease.
no, my lord, that notification is
Where is
also-
that notification? You have not annexed it.
No, under the OGLS Act, there is a notification, my lord.
No. They say that you are in possession under a registered deed of conveyance.
My lord.
You already have a registered deed of conveyance.
My lord, kindly see the notification, my lord. If your lordships permitted me to place this notification, my lord. That is the notification, my lord. Kindly see, my lord, procedure, my lord. Paragraph 3, my lord. Procedure on receipt of application. My lord. The Tahsildar shall initiate a case record on an application made in Form 1 by the occupant of such land and make a detailed inquiry as required, possession of such land, eligibility of the applicant, purpose for which land is being used, actual extent
You
of
come
land.
page 19, they say you are already in possession
My
under
lord.
registered deed of conveyance.
My lord, I am already in possession, but according to that notification, the Tahsildar should record that suit land in my favor. But without that, he rejected my application only a very cryptic manner, my lord.
Application is for grant of lease, and your your lordship may kindly see this order was of 2010. After 5 years, he has filed this petition.
No, my lord.
No. Is it for lease or for settlement?
My lord, it is a
lease.
No. It is not a lease. This is a Khasmal land. The petitioner applied under the government notification to record the suit land as a Stitiban land in his favor. That is the government notification.
Nothing is borne out from the.
No.
Then I may be permitted to get instructions.
All right.
Lordship may keep it to 2 weeks minimum.
Oh. All right. Let it stay on board, sir. Then. All right.